Yes.
May I please, your lordship?
Yeah.
Lordship, I beg to mention for listing of a criminal petition, your lordship, on next Wednesday.
What is its motion stage?
Actually, your lordship, we need to, actually it is an admission stage, but we need to file an additional affidavit, your lordship.
We file it.
Without the consent of this, order of this court, your lordship.
Listing order kola.
Deeply obliged.
Give in the order kola.
May I please, Lordship? I beg to mention for PA, Lordships.
Uh-huh.
Bail application was on Monday, Lordships. Because
Motion.
no, bail hearing, it was fixed before 3 weeks ago, Lordships.
No date was given.
Yes, Lordship.
Okay.
I'm obliged.
Intimate the PP so that they can have the case there, or this is
And this will be over, Lordship, on today.
today. Bring it today. But this bench is not sitting in the next week. Bring it today. As early as possible.
May I please, your lordship?
Yes.
So I beg to mention for listing BA lordship, two BA lordship for motion lordship. Can it be lordship on production list today lordship?
Today may not be possible. Monday.
Monday lordship.
May it please your lordship, I beg to mention item number 17, lordship. Matter may be
17?
come up after a week, lordship.
Uh-huh.
Item number 17, lordship.
17.
Matter may be come up after a week, lordship. We are newly engaged counsel. We need to file our additional affidavit. In
Okay.
certain
On the
documents on
prayer
record.
of the items on the prayer of the learned council for the petition, matter stands adjourned and be listed after a week.
After a week.
Give a date. Next week, give a date.
27,
Friday, next Friday. Next Friday is 7. Don't give 7.
idea.
12.
Please, lordship.
Case there.
One small request, my lord. The wife of the petitioner is referred to JMCH hospital. If my learned friend has some
Early date.
early, my lord, Monday or Tuesday, my lord.
We can try it, no problem on that.
Yes, catering home. Yes, on 5th of June.
That is the case, apprehension you
My-
filed.
my-
Now in the meantime arrested.
One is arrested, my lord, other case is, my lord, on 7th, my lord.
Okay.
Yes.
And deeply-
Tuesday on 4th of June.
4th, my lord.
Fourth.
My lord, deeply obliged.
CD on 4th.
Please,
When CD on?
lordship. Here, lordship, 19 years boy, lordship. If your lordship will peruse the
Just a minute.
affair,
Just
19
a
years
minute.
boy.
We'll take it
What-
up on even on Tuesday. Monday on Tuesday. It's from Dispur only.
This 4-6, my lord.
4-6? We do not know. Maybe 19, but there may be an apprehension of larger things involved.
Yes.
Maybe love affair. She's 16 admittedly. You may be 19, but let us see. On Tuesday. On 4th?
4th, my lord.
On 4th.
Obliged, lordship.
Female NBPS.
CD when?
On my lord, 28th of June, my lord.
28th of June.
Scan copy of certificate, my lord, lordship. Scan- scan copy.
Certificate?
Yes, lordship.
Yes, my lord, certificate case.
Where is the certificate?
Certificate case.
Okay, scan copies of
The NDPS case number. lordship.
scans copies of order of Sailobo, NDPS case number
95/22.
where do we get it?
Lordship,
95 of 2022 pending at Sailobo case page indemnity second indemnity arising out of Gorsuk case
along with case there, lordship.
along with the case diary of that case. Yes,
May please lordship?
CD
Yes.
On my lord, 13th of June.
13th of June.
Obliged lordship.
What was CD?
Yes, NDPS on my lord, 27th of June, my lord.
27th.
May
CD.
Lordship,
CD on my lord,
Was arrested,
8th of June, 26th, my lord.
Arrested on
arrested on
13/5.
13.
13 of
Actually, stolen materials was recovered.
Maybe, but it's a,
When
if you steal
was sent to
public
jail on
properties,
the-
there may be a date of somebody if you remove the manhole things. Okay, we'll see.
Yes, ma'am.
Give a early date if possible.
On 13/5, ma'am.
13/5.
13/6, ma'am.
13/6. Seven is not AB.
It's BA, my lord.
BA. Oh,
Posco Act, ma'am.
when?
My lord. 7. Please, your lordship. Only CD, my lord. On 19/6, my lord.
19/6.
My lord. 7, item number 7. Oblige. Maybe kindly taken up after some time. He is coming.
A pleasure, Lordship.
Hmm.
Lordship, Section 13 and 14 of the Assam Game and Betting Act, Lordship. I am not the FIR name accused, Lordship. But I received a notice under Section 41A, Lordship. The main accused has been already granted bail by the learned CGM after 3 days of the arrest, Lordship.
That was an interim bail only.
Not, Lordship. This is a
I'll-
final bail, Lordship.
I will
Team
put it-
main accused was granted.
And I am the driver of one Shivsaran Gupta, Lordship. He has been granted bail by this honorable court by order, Lordship. Kindly
Bail
come to this.
cancel.
That is pending, Lordship.
One we have granted by Mr. B.D. Kaur.
Yes, my lord, in, will have to check my-
Fukan was there, Makhanpur. So considering that only while getting interim for the time being.
interim.
Because
Because in that
the
case,
person who is much more involved than this, we have already granted because only on the, we have seen the case diary. The main accused was the other person. What is his name? Something Beria or something
Beria,
like that.
Prakash Beria.
Then other person who we have given, he used to keep the money of the Beria in his place. So that's why we have granted. He is a driver. So
Yes.
interim only, not absolute.
yes, ma'am.
CD interim.
Oblige.
Considering the nature of allegation involving the present petitioner, not general nature, huh? Involving the present petition. So far the same relates to the present petition.
On 26, my lord.
26.
Oblige, Lordship.
May I please, your lordship?
Why are you apprehending?
My lord, police is searching
Why?
me, my lord. My lord,
Who are you?
I am Kabir Ahmed Chaudhary. And
No, how you are related? The
I'm a
vehicle,
brother. I'm
brother of
brother of the accused number 1, my lord,
who sold the vehicle?
who sold the vehicle.
Then why are you apprehending?
My lord, what happened, my lord?
And who is Omar Farooq Chaudhary?
Umar Farooq Chaudhary is the brother, elder brother.
And who is
It
the
is
other?
stated- It is stated in the FIR, my lord, that the transaction is made in our house. my lord. And that is why police is
So
searching.
who is the other person?
Other person is the brother, my lord.
Brother of whom?
Accused
Both,
number 1.
both, huh?
Both are the brothers of accused number 1, my lord.
both are the brothers of accused number one.
One. And only
Accused
reason-
number one is arrested.
accused number 1 is arrested.
Otherwise, from the, my lord.
We have seen that. This is serious allegation.
Yes,
If
ma'am.
you can do from which place,
It is from Hujai, my lord.
Hosai, my lord.
you be there for you just wait for some time. We're calling for the case there.
Yes.
My lord.
No interim at this stage.
My lord, kindly only, my lord, only because
We do
all
not
allegation-
know.
all allegation is against
Allegation
the-
is serious. You
Yes.
might be involved in,
Yes,
may
ma'am.
not be named in that. You might be a part of this
Yes,
gang.
Yes, ma'am.
So we are just considering if nothing comes in, we'll grant you.
My lord,
CD.
only allegation against this in the FIR, my lord, that the transaction is made in the brothers of the first accused number 1, my lord.
We'll see. We'll see.
On
A short date, my lord, kindly.
on
Short it, short.
11/6, my lord.
Huh?
11/6.
11/6.
11/6, I have some problem.
Give her early that since no
Uh,
interim is there.
On, my lord, 7/6. then.
7/6.
Well, in the FIR, no small typical error, I may be allowed to correct, my lord. Oblige, my lord.
But give initial.
Lordship, lordship.
May I please your lordship? Though it is
Third,
a very
Mr.
serious
Talukdar,
matter.
learned counsel for the petitioner.
LCR and CD may be called for, madam. Scan copy of.
Full stop. This is an application under Swenso. Call for the scan copies of record of special session case within bracket POXO number 36/2023. Full stop. Comma along with the case diary of RK Nagar PS case number 22/2023.
Yes.
Full stop. Till receipt of such record, no coercive action shall be taken against the petition.
Yeah.
Date ready. Date like,
Date,
date, give a date. No, date you will have to give. Registry, it is scan copies. 20th.
date. Yes, my lordship.
Reported application, Lordship.
Mm.
Allegation is 37 under.
Why you are here? Tell us.
Lordship,
Who are you?
Lordship, I am the owner of the dam, Lordship, from where the stolen battery recovered, Lordship.
Okay.
So my manager is arrested, Lordship, for the recovery of that. I am the owner, Lordship. I do
CD interim.
CD on my lord.
Considering negativo nature of allegation so far relates to the present petition.
Well, because manager was already arrested, but he is.
We'll see, we'll reject it, let us see. There may be possibilities
Okay.
that he may not be,
May-
so it's not a serious offense that you need
Yes,
an
yes.
we'll
Interim,
see.
interim granted, my lord.
Interim grant,
Yes, then on 27/6.
27.
Maybe.
Yes,
First of all, here FIR is 8, Lordship.
we know that FIR is at page, but why are you apprehending? Who are you?
Lordship, because Lordship, the victim was also recovered, Lordship.
What is your name?
Lordship, my name is Sadhu Mia, Lordship.
You are the main accused.
No, Lordship, only Lordship.
164 statement will be required, my lord.
Why are you apprehending?
No, Lordship, can you see the Lordship, this 13, Lordship, the rejection order, Lordship.
Oh, I have seen that because rejection order says that we have perused the 164 statement. Therefore, there might be something. We'll see.
No, Lordship, one thing, Lordship, just, Lordship, may I submit, Lordship?
Yes.
If Lordship, anything adverse, Lordship, in the 164 statement, definitely there might be added some sections, Lordship.
Mm.
Only in the rejection order, it reflected, may be required for his interrogation, Lordship. Kindly see, Lordship.
See, there is no person is named
Yes,
in
Lordship.
the affair.
Yes.
Why are you apprehending? That is why I am asking.
Yes, Lordship, because Lordship.
Why have you approached the learned trial court? Let us understand that.
Yes, Lordship. That is why, Lordship, because the girl and the present petitioner, they visited their relative's house.
We'll see.
Yes,
When whatever.
on 13/6, my lord.
Can you pass over timing, Lordship?
Otherwise, I have received the report in all the cases, my lord.
What it say?
No case my lord, regarding my lord, Sunari PS, my lord, no case is pending at
Hmm.
Sunari Police Station.
Hmm.
And regarding my lord, Amguri Police Station, no case pending registered against the present petitioner. And regarding my lord, Merapani, no any case registered pending against the present petitioner.
Police will not, no cognizable offense is made
Yes.
out. Why should police will, and we cannot give a blanket orders that you should not be arrested in any case.
Yes, my lord.
So, close it.
Which not,
Huh?
which actions will be taken.
Coercive with action head. Suppose you do something and an FIR is registered. Can you give a blanket?
Hard coming.
The learned counsel for the petitioner. This court, প্রথমে তো দিব, second paragraph to আগৰ order লিখিব। In the aforesaid background, this court under its order dated 29/5/2024 call for a report from the call for a report as to whether any case has been registered against the petitioner in terms of the aforesaid newspaper publication in any of the police stations, in the aforesaid police station. Full stop. Mr. Botthakar, on receipt of,
The reports may kindly be
has
sent as a part of the-
received a report
all the cases.
in all reports, protected case বেলেগ করে দিব. The said report has been forwarded by the officer in charge of the police station, which discloses that no case has been registered in connection with the aforesaid case. In view of the aforesaid, there cannot be any apprehension of arrest. Accordingly, the present application stands closed. However, if any occasion arises, the petitioner shall be at liberty to approach this court once again. petitions stands disposal. এই তিনিখনে তিনটা কেছত ভৰাই দিম সেপাৰেটলি না আৰু ভালদৰে জানি চম একেলগে তিনটা
Standing matter, item number 8.
yes why
My lord, actually, nowadays there is a barcode and they have to trace out the for few days, my lord, that barcode is not working because of that. He could not have
few days means from which few dates
My lord, that is
this is pending since
my lord 9/5. My lord,
9/5 we are in the 9th of
subsequently, my lord, he stated in a report, my lord, he given a report, my lord, there is a vision murder case, my lord, for that investigation, he went to Sor area. Because of that, my lord, subsequently, when we send the, my lord, full address of the person, my lord, then he recollect, my lord. And now regarding that, this case, my lord, actually, there is only regarding monetary transaction. He asked to and put some question, otherwise, my lord, there and non-FIR case has been there, 219 of 24, but this is not registered, my lord. And because of civil nature, my lord, regarding only monetary transaction.
okay heard Mr. N.J. Datta, learned counsel for the petitioner, also heard Mr. K.K. Parsar, learned additional PP, Assam. Mr. Your name?
Professor Nath.
Sri Lakheshwar Nath, comma?
Professor Nath.
Hmm?
Professor Nath.
Possessor Nath, give the name. What is designation? Inspector,
Officer in charge.
officer in charge, Borpeta
Yes.
Police Station is personally present in terms of this court's order dated 31/4/2024 at 10 to 24 full stop. The officer has explained that due to some technical fault of what you call it, barcode,
My lord.
technical fault, he could not no that he could not report due to his sudden involvement in investigation of a murder case, which has murder case, and accordingly he seeks apology for not being able to send the report within time. However, he submits that petitioner should not have any apprehension in connection with any case, in connection apprehension of arrest, in as much as though one allegation was received in the police station, as the same relates, the same is of civil nature, the police has registered only on
Non-FIR case.
non-FIR case. First of that being the position and specific stand of the IO, not IO, officer in charge. This court is of the view that petitioner should not have any apprehension of arrest. Accordingly, the present petition stands dispense with. The apology sought for by the learned by the police officer is accepted. His personal appearance stands dispense with.
That non-FIR case.
You should inform that yes, I am having a problem, so I cannot. That is what we want. We are not that. You should inform him that, see, I have not been able to send. Please tell the court that this is the technical fault. That you can tell, which you can tell today. You could have told on that day. We would not have called you. And we do not like the police officer to call here. You are also having your job. And this is not our job to rebuke you. Isn't that it? Be careful. Yes.
Case number
No,
21.
non-FIR case number?
Case number 219/.
219/.
2024.
Good.
I'm obliged.
Yes. Hard. Mr. Arbora, learned counsel for the petition. The present petition is filed for quashing CR case number 07/2024 pending before the learned court of learned judicial magistrate first class Karbi Anglong at Difu. Full stop. The learned the further challenge is an order dated 11/3/2024 passed by the said magistrate, whereby cognizance of offense under
Section 294A
section 294A,
500 IPC. Read
uh,
with
section 294A IPC,
500
says
IPC.
500 IPC,
Read with section 67 of the information.
read with section 67 of the Information Technology Act was taken. Full stop. The basic ground of challenge is that a bare reading of the complaint as well as the deposition of the witnesses and the complainant recorded under section 200 CRPC discloses no case. Full stop. Issue notice returnable on give a date 28. Full stop. Considering peruse the complaint as well as the statements of the witnesses recorded under section 200 CRPC. Perusal of the same, this court is also of the prima facie view that no cases under section so and so are made out. Yeah, accordingly, till the return of the notice, comma, it is provided that further proceeding of CR case number so and so shall remain suspended. Go to mediation and finish it off.
Not yet. Obliged.
Only for that reason we have proceeded.
Not yet. Obliged.
Yes, Bhattacharya.
Lordship, this is the third seated case, your lordship,
Hmm.
under.
We'll go to the search. All these are search case today. Okay, we'll all search case scan copies will take a little bit later. Okay, so up to 22 we'll call for a little bit later. '23. Yes. What is the affair?
FIR is page number 8, your lordship, relevant portion is page number 10, your lordship.
Why relevant? Okay. Who are you?
Lordship,
Sanjoy.
one is Sanjay Dey and another is
Sanjay Dey is not
Pranay.
the petitioner. Malal.
Sanjay Dey, his father, Sujit Dey is the petitioner, your lordship.
And Tanjak Konyak.
He is a retailer, your lordship, who was used to purchase the grocery articles from me, your lordship. I am the wholesaler, your lordship. And resident.
Doubtful. Both of you have filed joint application.
No joint not Malal, joint.
Ah, by the same council.
Yes, yes.
Strategical mistake.
Lordship, actually.
It's a
Both resided
strategical mistake subject to
adjacent,
what
your lordship, of
the case diary says.
both villages are.
Malal, Sanjay Dey was not arrested by police. He is the father of Sujit Dey.
Son, we can we are otherwise we are thinking that there may be demand out of force they have
But
given it.
They have not intimated the police. That means
That
they
is, but
evaded the permission of
how is this Tanjak Konyak?
Tanjak Konyak, Malal, through the present person, Malal, he paid the money to Ulfa, Malal.
Is not a member, your lordship, admittedly in the FIR, your lordship.
Understand how Tanjak is relative?
Because he is the Sujit Dey is having a retailer shop at nearby.
That is
Kanpur
that
Estate,
is with no.
and
So if this petitioner is a son of Sujit,
son of Sanjay Dey.
Sanjay.
sons of Sanjay.
Sanjay Dey.
Sanjay is having a shop.
Sanjay is having a shop. Malal, he is the son of the Sanjay.
Son of Sanjay. Now
The demand was made by the band organization to the mobile phone of Sujit Dey.
Hmm.
He intimated his father. Thereafter, in 2 installments, first 3 lakhs and next 1 lakh paid through the petitioner, Malal, the Konyak, to the band
I want to know Konyak belongs to which place?
he is from Nagaland, Malal.
Adjacent to the, your lordship, the Sujit Dey house, your lordship. Although estate are separate but nearest, your
That
lordship.
is the strategic
And I have
mistake.
business, your lordship, at Nagaland, your lordship.
Sujit Dey also involved in abetting the commission of the offense. Why he has not intimated the police, Malal? Otherwise, they.
But that also we can consider in a situation, those two incidents. Okay, out of the fear, okay, fine,
Yes.
to that extent. But why both are by the same council?
Yes.
Actually, both are he is a customer, your lordship, he come to my shop, your lordship, and my shop is resident near to the resident of the Prajat Kanayan.
How many days?
When organization has collected money from this person, my lord, from his house at Nagaland, my lord.
That's lordship, allegation not correct, your lordship, and nothing else, objectionable article recovered, your lordship. There is a seizure, your lordship, page number 16, your lordship. He come to my shop, your lordship, as a customer, come to shop of Sujit, your lordship.
Or you are taking money from your own father with cognac. That may be also a situation.
Yes,
Who knows?
yes, maybe.
Sujit, they not paid, your lordship, Sanjay, they paid, your lordship. Not Sujit. Page number 16, your lordship. Nothing any objectionable recovered, your lordship. Custody, your lordship, custody schedule may kindly considered, your lordship. Rajang Kanak is a Naga person. And near his resident, my shop is there, Sujit shop is there. He has been running his shop nearest to the house of Rajang Kanak. He was present at my shop, your lordship.
Where are their statements? What about?
Last page, my lord, statement of Sujit De, my lord.
Huh?
Last page, my lord. Statement of Sujit De. As per his statement, the present petitioner Konyak is his customer for last 10 years. That is his stop statement.
Where is the statement of Tanjang?
Tanjang statement, my lord, that is the, I have not, I will try to find out regarding it. His statement,
That is the link, that link is meeting. How this person entered into the scene
yes, ma'am,
and why this man is trying to protect Tanjang.
yes,
He's a man from Nagaland.
yes, ma'am.
Whole transaction was done through him.
There, yes, madam.
Yes, Musumi.
It's a
Only
customer
he-
your lordship. It's a true fact, your lordship.
Statement
Very
is,
simple person on minor boy, your lordship.
No, no, you have many customers. Why money was given to him?
I have retail shop. Tajang has retail shop, your lordship, and Sanjay Dey is a wholesaler, your lordship. Used to purchase the articles
No,
from the
no,
Sanjay Dey shop.
understand.
And Sanjay Dey shop is nearest to my house, your lordship.
No, why this person?
Police
Money is demanded from you, you pay the money. Why this person is the middleman?
found him at the shop of Sanjay Dey, your lordship, and arrested him.
How do you know the alpha person and how they are collecting the money from him?
The FIR, your lordship, is not a member, your lordship. As per FIR, your lordship, allegation is a mediator, your lordship, agent, your lordship. As per FIR, not a member.
Anything
Naga
that who is this Lahon?
Lahon is the person, my
Lahon
lord,
is
who made phone calls to the, my lord, demanding money, my lord.
Is the main category, your lordship.
Why he has, my lord, selected only this petitioner to pay that money, my lord, from Nagaland? And why? And also, my lord, also arrested only on 4/5, my lord. Some more investigation will be required. My lord.
Not right now.
Yes,
It may not be necessary for 39 your lordship.
Hmm?
The minor school going children, your lordship. Wife is also seriously ill, your lordship. He is a not member, he is a customer, your lordship. That's admitted by the Sanjay Dey, your lordship. That is a customer and
No,
the
that
shop is
in fact we are a
nearest to my
little,
house.
we just, what further investigation will you do?
Sir.
You can also do nothing.
Kindly allow
There
me
is
to say that.
nothing on record to show that you can either arrest Lahon or track him out.
It
You
would
have
be
not been
difficult-
able
it
to
would-
find
it
out
would
who is that unknown
It
person.
would be difficult to arrest Lahon, my lord, admittedly.
Never. At
But-
best you can, who is a Lahon is an accused.
Yes. I'll get further instruction on any after next week, any day.
Next week. Mr. Bhattakur submits that though case diary is
It
received,
further
he may be granted a week's time to get further instruction and obtain an updated case diary
Yes, on 11/6, man.
on list this matter on
13/6,
11.
man.
Huh?
13/6.
With 13.
11 your lordship.
Okay, 11/6.
Yes.
Pleasure, lordship.
Case diary is returned. Let us see on
Yes.
11. Too early.
Pleasure.
Doing case is not sufficient. How you strategize to do the case is more important. Yes.
My lord, I'm very sorry, my lord. That day I was facing grilling in court 1 for 4 hours, my lord.
Drilling.
My lords.
Okay, what is this? Tell us. Let him
Well,
go.
My lord, no, my lord, these are punishable offences, my lord, non-bailable, and my lord from the other state. And this on no, this court, my lord, in many occasions has held,
Now
my lord.
tell us the procedure.
Procedure, my lord, a complaint is filed under section 55, magistrate is taken into cognizance, then the person is given a he is given a chance to give his statement, which is also, my lord, according to section 50, subsection 8, my lord, it is admissible, my lord. And my lord, the bar of Assam Forest Amendment, my lord, which is somehow a slight at par with NDPS, my lord. The court has to draw satisfaction, and it is his own admission, my lords, in the petition, my lord, that he was in possession of ivory.
Where is the statements and all, if we do get it.
First, I'll come to the petition, my lords.
Mm.
Petition page 3, paragraph 4.
Page 3, paragraph 4 also.
Page 3.
Paragraph 4, my lords. By row.
Where is the complaint filed by you?
And it is. It's in the petition.
Complaint
my
at page lordships, 11 lordships. No, not 11 lordships, it's page 8 lordships. Page 8 in application.
No, my lord, it's page 10, my lords. Preliminary offense report, that is. the
This is
complaint.
preliminary, yeah.
Page 10. That is preliminary, my lord, and offense, final offense report, it is at page 13.
Page?
Page 10 is the preliminary, my lord,
Ah.
CJM, my lord.
Ah.
And page 12 and 13 is the, my lord, final offense report. Amendment to details. Amendment. Amendment.
Where is the carcass? Just for my.
No, my lord, not carcass, my lord. He was found with the ivory.
No, he, according to him, he made a statement that he saw that,
That is in Arunachal, my lord. That is in Arunachal. He is a resident of Arunachal. Well, shall I hand over the amendment, my lord?
now, where is the seizure?
Caesar, my lord.
Who is the seizure witness?
Yes. Caesar witness. My lord, Caesar witness is at page 12, my lord will find a forest guard, my lord.
Page?
Page 12,
There is
Bottom,
no
my lord,
requirement of any independent witnesses.
my lord.
There is no requirement of any independent witnesses.
My lord, sometimes, my lord, in a.
No, not sometimes. I'm not saying what
there
are you
is
doing.
sometimes
I am
there is requirement.
asking you what is the procedure because you are saying that this is a stringent act.
My lord,
If it is stringent,
My lord.
the law is well settled that it should be scrupulously followed.
my lord,
Now I want to know what is the provision of seizure, in which section,
my lord.
how to do a search and seizure.
Search and Caesar. Like 50 to say. My lord, section 50 lays down the procedure of the Wildlife Act.
15,
50, my lord, 50.
50 of the Wildlife Act. Wildlife Act. not Forest Act, Wildlife. You just read it.
My lord, prevention and detection of offences, power of entry, search, arrest, and detention.
Hmm.
Notwithstanding anything contained in any other law, for the time being in the force, the director or the any other officer authorized by him in his behalf. My lord, it is a bracket, or the management authority or any officer authorized by the management authority. Again, bracket closes, my lord. On it, or the chief wildlife warden or the authorized officer or any forest officer or any police officer not below the rank of sub-inspector or any customs officer not below the rank of an inspector or any officer of the Coast Guard not below the rank of an assistant commandant may, if he has reasonable ground for believing that any person has committed an offense against this act, require any such such person to produce for inspection any captive animal, wild animals, animal article, meat, trophy, or trophy, uncured trophy, specified plant or derivative thereof,
Hmm.
or scheduled specimen of his control's custody or possession, or any license, permit, or
Hmm.
document granted to him or required to be kept by him under the provision of this act.
Hmm.
B, my lords, stop any vehicle or vessel in order to conduct search or inquiry or enter upon such any premises, land, vehicle, or vessel in the occupation of such person, and open and search any baggage or other things in this possession. Number C, well, seize any captive animal, wild animal, animal article. Well, the issue we are dealing is animal article.
This is 50,
Section 50, my lord,
Sub-
sub C. I'm reading and C.
Okay. 51C. Okay.
51C, my lords. Seize any captive animal, wild animal, animal article, my lords. This is animal article. Meat, trophy, or uncured trophy, or any specified plant or part or derivative thereof, or any scheduled specimen in respect of which an offense against this act appears to have been committed. In the possession of any person, together with any trap, tool, vehicle, vessel, or weapon used for committing any of such offense, or unless he is satisfied that such person will appear and answer any charge which may be preferred against him, arrest him without warrant and detain him. Number 3, my lords, that provided it's about a fisherman and a national park, my lords. I'm just skipping that. Number 3, my lord, it shall be lawful for any person referred to in subsection 1 to stop and detain any person whom he sees doing any act for which a license or permit is required under the provisions of this act for the purpose of requiring such person to produce provision of this act for the purpose of requiring such person to produce a license or permit, or if such person fails to produce the license or permit, as the case may be, he may be arrested without warrant unless he furnishes his name and address and otherwise satisfy the officer arresting that he will duly answer any summons or other proceedings which may be taken against him. Any officer, my lords, or of a rank or not inferior to that of an assistant director of wildlife preservation, or my lord, who or whose subordinate has seized any captive animal or wildlife animal under clause C of the subsection may give the same on custody and execution by any person or bond for the protection of such animal. Man. This is regarding the animal. Man. Any person detained or things seized under the foregoing power shall be forthwith be taken into a magistrate to be dealt with according to law, under intimation to the chief wildlife warden or the officer authorized by him in this regard. Any person who, without reasonable cause, fails to
What is the it's here offense? Schedule 1,
Schedule 1, my lord, elephant tusk. Killing, my lord, will perhaps, my lord, it will need some strict proof, my lord. Otherwise, my lord, he was found in custody of elephant that ivory, my lord, amounting to almost 2 kgs, my lord. Not 2 kgs, my lord. If my lord goes to the page 10, approximately 4 kgs. If my lord may allow me, my lord, in many occasions, my lord, this honorable court, my lord. Well, this was the first time, my lord, this amendment was pointed out before this honorable court. This is a case of pre-charge sheet. And only 2 days were left for the charge sheet. Even then, my lord, the honorable court held that these provisions are stringent and had to be executed, my lords, in a very strict manner.
Now you want to say now 51A, what will happen to 51A then?
Well, 51A has been amended in Assam.
Okay,
So, my lordship will kindly take the amendment, my lord. That-
okay.
My lord, the punishment initially in normal wildlife act, it was 3 years.
So
which
in
makes-
Assam, 51 B will be applied.
Yes, my lord. Twin conditions are there. Punishment has been enhanced, my lord. 3 has gone to 7, 7 has gone to 10.
Okay, that we understand. Now let us see the statement of the, what is the stage now?
My lord, it is the almost, my lord, it's almost on the verge of completion. My IO has been called to adduce evidence, my lord, on 10th.
10th.
10th, my lord.
6 is absent, lordship. 6-5, lordship.
এইটো কিতাপখন দিছে নে?
What about Dudul Sangmai?
My lord,
Dudul Sangmai, the person.
he is yet to be, my lord. What matters? Number 19. Jalap Khan.
Okay.
And also, my lord, if my lord, the section 57 Wildlife Act, my lord.
Hmm.
Presumption is, my lord, on the other side, my lord.
57.
57, my lord.
Yes. Difficult.
Lordship, he is more than 4 months in custody,
No,
lordship.
no, that is not the important thing
Okay.
here. You have to satisfy
Lordship.
and that position, you have admitted your position.
Lordship.
So moment you admit your position, presumption is upon you that this was a legal position.
Lordship, that time made a statement that.
That
lordship, he has-
statement will not do in terms of the trophy.
Okay.
You will have to register it on a
Okay.
cutoff date. There is a cutoff date.
Mm.
In absence of that, we cannot give you the benefit.
In the trial, lordship will establish that, lordship, his position, this is legal, lordship, in trial court, lordship.
So therefore, it is a satisfaction is that so far relating to bail.
But in 51, lordship, 51, it is, especially it is a first offense, lordship.
No,
The
No,
first
that is no more applicable. I was also initially that understanding. 51B, which says where public prosecutor opposes the application, the court is to satisfy that there are reasonable ground for believing that the accused is not likely to commit any offense. Not any offense while on bail. So where do we get this? 10th is the
my lord.
IO.
IO, my lord.
We'll consider now you do one thing. We are closing it. Do you want a rejection order or we want to withdraw so that after the IO is examined, you can come once again?
When I fix it on after 10 lordships, then I will wait lordships.
It is submitted that let us see on 10th. Yes, Mr. Gobek, finish it.
My lord.
Yes, then we must consider that you are delaying the trial. Then we'll go to that Article 21.
My lord.
Then we'll go to the Article 21.
That I will answer, my lords.
Huh?
That is, I
No,
will.
that we have already answered.
The new
We-
answer is that. my
A
lord.
new answer,
Yes.
we do not think that answer has come. Rather, Supreme Court is even is more lenient than what we have laid down.
My lord,
We have
no,
made tried to make a balance that 37 will be required in NDPS. However, that can be an additional ground. Now the Supreme Court is saying that forget about 37. If Article 21 is violated, and that if delay is on your part.
If that question comes, I can answer, my lord, if that question, because
No,
recently-
your answer will be not relevant because already answer has been given by Supreme Court and this court. Until and unless you go to the upstairs.
very recently, my lord.
Recent I've seen that. Every day I'm dealing with NDPS.
Not NDPS, my lord, wildlife, my lord. Certain issues
I'll-
were raised, my lord.
What is the principle?
My lords.
Even NDPS is stringent because how to seize their procedure is given.
Yes, yes.
Here it is not given.
Hmm. No, it's there, my lord. I'm sure.
No, only this is there. How, what should be the independent witness? All these are there. Here we have not seen.
My lord.
So I will say that this is much more stringent. So we'll be strict.
My lord, if the challenge comes, we will answer. my
not
lord.
challenge.
After 10, my lord will see.
But you get a certified copy what happened on 10th
Lordship.
and produce it
Lordship.
before us.
My lord.
Okay. It is submitted that the next date before the trial court is fixed on 10th of June 2024 for the evidence of the, what you call it, IO? Complainant. Complainant.
Complainant.
Complainant slash IO. Complainant slash IO. And therefore, and accordingly, Mr. IO, full stop. It is submitted by the learned counsel for the petitioner that the IO, in spite of receiving of someone, is not appearing before the court and resulting in violation of the petitioner's right under Article 21. Full stop. Be that as it may, since the matter is fixed on on 10th, let this matter be fixed on not 11th. You'll have to have a copy, no?
12, Lordship.
12th or 13th. 12th of 12th.
Oh, Lordship.
Twenty-five, my lord, case diary not received. Petitioner is in interim money.
25 case diary not received interim when?
On my lord, 27th of June.
27th of June, interim to continue.
Twenty-six, my lord, charge sheet submitted in this case.
Any interim?
Lordship,
Interim is there.
Huh?
charge sheet has been filed, but my name is not there in the charge sheet.
Your name is not there in the search sheet.
No, Lord.
Fine, very good. The present application under section 438 of the Code of Criminal Procedure 1973 has been filed by the petitioner, namely Dipanjal Hazarika, who is apprehending his arrest in connection with Lakhimpur PS case number 75/2024 under section 406/420 IPC. Full stop. Mr. Borthakur, learned counsel, additional public prosecutor submits that after completion of the investigation, the IO has submitted search sheet
Yes.
being
68/24.
68/24 dated
34/24.
34/24. Full stop. The learned counsel for the petitioner at this stage submits that though search sheet has been filed, the petitioner has not been sent for trial as an accused.
To our instruction, his name is not there in the charge sheet, my lord. That is what.
That's all. And in view of the aforesaid, the present application stands closed. If anything is there, you are search sheeted, you come again. Otherwise, you have interim, you have statements are you will not be declared as an absconder. Yes.
27, 28 also, my lord. Same PS case, search sheet submitted.
Same PSK search sheet submitted. Are you an accused?
Yes.
Huh?
Interim is there.
Interim is there in both cases.
cases, ma'am.
Agor khini hobo. This court interim order will continue till shall be at liberty and interim order shall continue till the petitioner receives summon from the learned trial court below and appears before the court and file an application. Same. Same, is not it, Bhattakur?
Yes, my lord, both cases, my lord,
both cases
27
same
same. CS number 47.
Okay, CS number?
CS number 47/24, dated 29/4/24.
Oh, then I thought that it is same with item number 26. Anyway, no, okay. And now I'm corrected.
28 is same.
Same, okay. I thought it is with
yeah.
26.
Like here we are in time, my lord, we appeared before the IO, my lord.
Yes, Bhattakur,
My lord, case diary received.
do you want his custody?
Till now, police has not yet collected, so when they appeared, statement recorded. my lord.
Dispose of. Absolute.
Fair please, your lordship.
Yes,
430 application, my lord. The allegation are, although my lord serious, my lord, the all the documents has been seized, my lord. Your lordship will find it page 14, my lord.
is
14, my lord. This
that
is a-
case, same case, that arrested.
No, my lord. This is a, my lord, allegation is that I have submitted forgery certificates while applying for the SSB jobs, my lord. The page 14, your lordship will find, with reference to the subject cited above, I am to inform that two communication by the order reference under received
Where,
From-
where are you reading?
page 14, my lord.
Page 14.
This is the FIR, my lord.
What is page 16? Okay,
My lord, this is communication, my lord, that I have been already been, my lord, discharged from the job, dismissed from the job, my lord.
any writ petition pending?
No, my lord. The following documents in original are enclosed here with my lord. The original documents has been seized, my lord. My name is appeared in the serial number 1 is Norendra, my lord. Yes, there he was called
How
for.
many years you served the force?
It is an initial stage, my lord.
Initial stage?
After verification.
After interview, my lord, I have been caught. My humble
You are
submission-
Narendra
I am
and
Narendra.
Shiva, not only Narendra. Yes, what you say?
Otherwise, my materials are there, because he has, my lord, forged the signature of my
Hard, Mr.
ADC, magistrate and all.
Capital punishment I have already received, my lord. My lord, there is no, my lord, there stands for hampering and tampering the evidence, my lord. Always
TKPR,
seized.
Learned Counsel for the petitioner also heard Mr. MP Goswami, Learned Counsel for the response. Additional Public Prosecutor. Present application is filed. Swenso. The allegation leveled in the FIR is that the petitioner, along with another accused, had submitted forged documents by using fake seal and signature of the additional deputy commissioner Sonitpur, Tezpur, and executive magistrate Tezpur subdivision Sonitpur. Full stop. During the course of their selection process as
SSB constables, my lord.
SSB constable. Full stop. On the basis of such FIR, on the basis of such allegation, FIR dated, the aforesaid FIR was registered. Full stop. It is also the case there was called for Swenso. From the case diary, it is seen that these two petitioners has already been terminated from their job by order dated 7/3/2024. Full stop. The case diary further reveals that the investigating authorities has already seized the forged document and also examine the witnesses. Considering the fact that the investigating officer has almost completed the investigation, in as much as the case involves a forgery and evidence are primarily documentary evidence which has already been seized and sent for forensic examination.
My lord, yes, my lord, the certificate that he produced, my lord,
Mm.
that the report has come from the district magistrate's
Full
office
stop.
and others.
As well as collected reports from authorities
District
who
magistrate.
who
unit to-
purportedly issued such communication. Full stop. And statement of the said authorities has also been recorded. Considering the matter in entirety, this court is of the view that at this stage, the custodial integration or interrogation of the petitioner may not be necessary. However, accordingly, the present application is allowed. However, it will liquidate within period of 10 days and shall not involve in similar offenses. Okay. Upar likhibo, Mr. M.P. Goswami has seriously objected to the prayer of bail on the ground that there are sufficient material to suggest that the petitioner has used fake document for their benefit, and in fact they have themselves forged these documents. Full stop. And therefore such persons are not entitled for benefit of privilege of pre-arrest bail. তাৰপিছত
MDPL.
Kate, my lord, just, my lord, CD has been received, my lord.
Mm.
I want 1 day, my lord, to time, because it's a,
okay, Monday,
some expects, yes, my lord.
Monday.
There is no interim also, my lord.
Well,
Civil
till
dispute,
Monday,
my lord.
till Monday.
Civil case.
Learned CD is here, they will not
Yes,
arrest you.
preliminary, I have seen. my lord,
You
they
are
thinking
already on
this.
interim, CD is here. Mr. Goswami, learned counsel submits that though he has received the case diary, he needs some time to go through the same. Accordingly, the matter stands adjourned and be listed on Tuesday next.
No, obliged.
Date to due. Yes, Parasar, what is this review?
But with very limited prayer, my lord.
Yes, tell us.
Regarding, my lord, this.
What was the matter? I have not gone through it. What was the
Matter is
direction?
regarding, my lord, appointment in CAPF, my lord, several, my lord, BSF, CRPF, and all these, my lord.
Okay.
There, my lord, written, then physical and all this.
So if you say that there is a case for review, will issue a notice?
Only my notice, my lord, yes.
Notice. So we'll issue a notice today.
My lord.
Okay.
My lord.
Heard. Mr. Parasar, learned counsel for the petitioner, decision application seeking review, so and so. Issue notice returnable on give a date. After vacation?
No,
Or
my lord, because contempt is also, my lord, they have filed. And certain development has took place, my lord.
okay, you do one thing. Who is the other side counsel?
Other side council, Mozumdar, my lord.
D. Mojumdar. We'll say one thing. Let us not say anything. Heard Mr. So. He is appearing in contempt also. List this matter on Wednesday next. Reflecting name of Mr. R. Mojumdar in the cause list. Let us see. Let us bring first Mr. R. Mojumdar
My lord.
instead of issuing notice. If you have a case, we'll allow it.
My lord.
If you don't
Limited,
dismiss it, that's all.
Sorry
Alright.
to interrupt, my
Huh.
lord. In item 25, my lord,
Huh.
the date has been given for CD, but just now we received that search sheet has been laid down, my lord. So my friend is also there, my lord.
Item number?
25.
Are you in interim?
Yes.
Interim. CS number
CS number 32, dated 27 to 24,
32, 27,
to 24.
20. Interim is there?
Yes, your lord.
Yes, dispose of.
Apply, your lord.
And I have been filed for clarification of the order, my lord.
What is the correction?
The complaint case has been filed in the order, it is written FIR, my lord.
Okay.
Para number 3, my lord, in the IA, my lord. My lord, may peruse.
So what? That is the FIR that was registered as FIR.
No, my- It's a complaint case, my lord, in the AP.
Complaint case.
It's a FIR hasn't been registered till now, my lord.
Then how can you grant and
Taken, my lord, from the.
so where is the question of anticipatory bill? You will issue a summon. Why have you filed an anticipatory bill?
Because, my lord, he has an apprehension that he will get arrested, my lord.
Arrested by whom?
My lord, by the police officer, my lord.
Why? Where is the role of police?
My lord, a warrant of arrest has been issued, my lord.
You would have said that give the file. This is the difficulty for you. This is not a mistake of this court.
My lord,
This is your mistake.
Yes.
You have made such kind of submission. We are under impression that CR case was filed, then it was registered as an FIR. We'll stop believing the lawyers. So there cannot be any applicable bail 438. You'll have to file a 482
Yes.
seeking recall of the NBWA.
there are judgments to the fact that then.
Okay, so was the judgment. We'll
Right.
dismiss right now.
My lord, I don't have the judgment.
Oh, bring the judgment.
My lord, anticipatory bail can be granted, my lord.
No, granted, we are not granting it. There is Kentenau judgments where it is said that in case of issuance of warrant, it can be a subject matter of revision. This was. You withdraw it, file it. We are dismissing this petition. Where is the order? Order of warrant.
The local council has been informed me that the warrant of arrest has been issued.
So where is that? That's why we have called for the case diary. Where is that warrant?
I don't have one.
Learned counsel for the petitioner prays
I
that
will
he may be
withdraw.
allowed to withdraw this petition and file a fresh petition inasmuch as the warrant of arrest issued by the learned magistrate in CR case number 22 of 2022 has not been annexed in the present writ petition. Petition, full stop. Accordingly, the present application stands closed. Interim order passed and order stands vacated. Petitioner shall be at liberty to file appropriate application seeking redressal of his grievance against order of cognizance / order of issuance of warrant by the learned magistrate in CR case number so and so. In view of order passed in so and so, IA stands closed.
My lord, I also might have overlooked that in the court side.
Really disturbed. I'm really disturbed seeing all this. The blame will go to us. Nothing on record to suggest that it is a pending trial. Generally, CR cases are also you also thought that because there is no order of any cognizance, there is no order of any warrant.
18 months.
Yes,
Lordship, LCR is there, your lordship, scan copies. A case charge seated under section 4, your lordship. Mainly, your lordship. 342, 376, your lordship, read with section 4 of POCSO. The man is behind bar for 290 days, your lordship. And the statement of the informant as well as the victim has already been recorded, your lordship.
Office note suggest my service report is awaited, my lord, last office note.
Through OC, we have already served, your lordship.
Mr. Bhattacharya, not a case. I've gone through it.
Not-
Difficult.
Not a, my,
You have
no
said,
merit, your lordship.
I understand,
Lordship.
but be there for some time. At least we can give you benefit later on. Or you can repeat the prayer before the session just. Not at all convinced. I've gone through. That's why we have adjourned this case. I tried to convince myself. I'm expressing my views. Better not to press this, or we are passing an order dismissing.
Your lordship fix some other day.
Some other day, list this matter after answering some other question. Yes, eh?
May I praise your lords?
Yes,
Search case, my lord.
yes.
I'm in custody for
Where is the FIR?
FIR is at page 12, my lord.
Page 12.
Yes.
Offense is under
NDPS Act 21C.
21C.
4.109 kg morphine was
11
recovered.
1190.
4.109. FIR is at page 12, my lord. It's a
Page
long FIR.
12.
Yes, my lord. Ma'am, lord,
Yes.
just to inform you that reliable information was
What
received-
is your name?
I'm
Mohammed
Mohammed
Iqbal.
Iqbal. I'm
One
a dri-
petitioner here.
Yes, my lord.
Two petitioners, one has been discharged, my lord. One man, two accused, my lord.
Two accused. There are
one-
two accused. One is
one is
discharged.
Three accused.
Three accused.
Three.
One is discharged.
One has been discharged. He is the main accused, my lord.
And you are
I'm
the,
driver of the vehicle.
okay, let us see.
This is to inform you that the reliable information was received from a reliable source at 2:05 PM on 19 February 2023. As per the information, a large quantity of suspected narcotic substances, that is brown sugar, heroin, etc., will come in a loaded body truck bearing so and so number from Manipur and heading towards Bokagan. Accordingly, ZD entry was quoted by me, white ZDN number so and placed a special Naka checking duty on NH 37 near SBI Khatkati branch under the leadership of OC Khatkati PS. The police party headed by me with the following police personnel was there to assist me by ZD entry number so. Then the names are there. I, along with the police party, used department bolero vehicle bearing so, which was driven by Raju Singh of Khatkati PS. We proceeded from the place of occurrence at 2:15 PM and placed special Naka checking duty at the Khatkati on NH 37 near SBI Khatkati branch at about 2:20 PM. And checking was started then at about 5:10 PM. The said 14-wheel vehicle bearing so number was intercepted. And after collecting authorization certificate from CA Borpathar, I called few local police and also requested them to witness the search process, and they agreed to be witness. Then the names are there, my lord. I am escaping that person and asked them to search the police party before searching the vehicle. They agreed and they searched the police party completely. After that, I, along with the staff, searched the vehicle, driver and occupant, but nothing could be recovered on that day. Hence, the vehicle driver and occupant was detained and brought to the PS and kept the vehicle under proper guard duty. And also, a
Okay,
pair-
okay. Now, so this, where is the order of discharge?
that is that. I have downloaded that from the.
It is in the LCR also, my lord.
It is also
But I have marked it.
at,
It
that
is
is at
first
page-
bringing order, my lord.
What is the ground of discharge of the other accused?
My lord, he is not the main accused as per that order, my lord. Entire order is.
No, just tell us,
Yes.
it was a possession from a Bolero
the truck, my lord.
truck. Both were inside the truck.
Yes.
And it was brought out from the glove box.
Inside the cabin.
Inside the cabin glove box by the sniffer.
Yeah.
Now, who discharged the
No.
other person?
Other my lord, not this my lord, not the two persons, they were not discharged my lord.
The
Another
person was the
person,
owner of the vehicle, my lord.
another
has been
person was
discharged.
discharged my lord. Not these two
Okay,
persons,
these persons were, the
And they were-
discharged person was not
not
present at
not
the,
present at the-
okay,
that is
then
my
it's
lord.
fine, okay. Then it's fine. I thought that the
No,
other
no,
person
not-
was this.
It is one my lord, Goni.
He's the
my lord.
owner of that vehicle, my lord.
Maybe.
Hmm.
What is their statements, this driver, these two person statement against that person,
Yes, my lord.
owner?
Yes, my lord. In fact, the son has been arrested with it. The other occupant is the son of that person. He has named his father, my lord.
He has named his father,
Yes.
but their statement under 67, without any corroboration, their statement is not an inadmissible evidence. So that he's granting benefit to the father, maybe the owner will not be beneficial to you. Now, what is your case?
Now, my lord, the quantity has been recorded from the inside the cabin of the vehicle. And I am not the regular driver. I was called to drive that vehicle up to Bukagan. I was a casual driver, my lord, not the regular driver of that vehicle. I just, as per his direction, I have taken that vehicle to deliver some
But
cement.
you belong to the same locality of the
Yeah,
same.
I belong to the same locality. Occasionally, I drive the vehicle, my lord. I was, prior to that, I was called to drive the vehicle to
That
deliver.
cannot be a ground for bail. 37 regard, where is the seizure? Statement regarding seizure.
Seizure my lord, your lordship will find I have flag mark my lord. The NCR portion, like seizure is found.
What is the stage now?
Is my lord, in the stage of evidence my lord, after charge. my lord.
Already 17 days have gone by. Only one witness has been examined.
How many days is pending?
8 witnesses, 8 witnesses.
Now, what is the total witnesses?
8 witness, my lord.
Total 9
One examine, my lord, that I have learned from my.
Just let us understand. Yes.
8, my lord. That is
informant.
not reflected in that, my lord, not reflected in the
Informant.
NCR, my lord.
Informant. 1, 2. And 8 witnesses examined. Date of arrest?
22/2023. I mean,
Date
custody
of
for
arrest 20,
2023.
2002,
23.
2023.
I mean, custody
And
for
date of search sheet?
date of subsidy is 34/2023.
30/04/2023. Date of framing charges?
6/9, my lord.
6/9/2023. Date of framing charge.
Yes, my lord.
Okay.
Already 17 dates have gone.
20. Now already
witnesses.
17 dates gone
For evidence, my lord.
for evidence.
Only one witness has been examined.
One witness examined. Difficult.
In view of Supreme Court
One-
decision, my lord.
No. Supreme Court decisions are there,
No.
but Supreme Court decisions are all above 3 years, 2 years. And we have, after relying on all these Supreme Court judgments, this court has taken a view that 37 will remain. Of course, that can be an additional ground
Yes,
in a given case. I think this is not that case. You have two options, either to come after this witnesses are examined, this seizure witness. If they are second, we'll grant you.
Already 17 dates have gone by.
No,
only
that will not be possible. Two options, either we decide on merit or with an option that they may approach this court and will observe that court, that prosecution will produce their witnesses as and when dates are filled, and unnecessary shall not delay
Sure.
the things. That two observation, or we can decide on merit.
Let it be pending for some time, my lord.
But sometime it will not come immediately.
Yesterday was,
Okay.
yesterday
Mr.
was a date fix for.
Okay, let us see. Mr. Rajsekhar, Learned Counsel submits that matter may be adjourned Prayer is allowed, list this matter. July.
July.
After July, let us see what happens. Huh? 16th of July. RBI along, this is the problem. So many cases, we are trying to do something. Let us see.
No.
We'll pass this order today.
Yes.
Yes.
May I please, Your Honor?
Yes, what is your case?
Similar the such-seated matter, my lord, an 18 years old boy, my lord, the victim girl, she is as per the FI 17 years. She voluntarily came, my lord,
Now,
and
what is the stage now?
she is, my lord, search not yet framed, my lord.
Charge not yet
Not
framed.
yet framed, my lord.
Where is the statement of the victim?
Victim, my lord, that is, my lord, reflected in the charge sheet itself, my lord. If your lordship kindly come to page 22, my lord, of my charge sheet, my lord. So as per 164 statement, my lord, serial 2, my lord.
Yes, madam. What you say? Romeo and Juliet, in some judgments today, some court has observed this is a case of Romeo and Juliet. Some Punjab High Court or something like. We are not observing that, but just what to do? A 19 years boy. You are also 16. Have you gone through a 164 statement? We will not say that this is a consent. We are not commenting anything on merit. Let a person not consensual might not be consensual. But I do not think if you give them stringent condition, don't go even, don't
Yes,
talk
yes,
to
my lord.
this.
In fact, my lord, we surrendered both of us, my lord. Not arrested even, my lord.
Don't try to revive the relationship.
No, her consent is of no value. Even if she would have said that it is with consensual, she has not said forceful, but either if you would have said consensual also, then also her statement is not having any value. That we are aware of that proposition. But given facts of this case, let us not make a criminal.
No.
He is also 19 years. Had it been a young older boy, she is a minor. He has also just attained the majority. But if she will record your objection. We'll pass this order Monday. Dispose of.
Your lordship. My lord, FIR, my lord, your lordship will find. First, my lord, it's a POXO case, my lord, not
Ah.
charge sheeted, my lord. It's a.
Sarcited.
No, not sir. Earlier, it is wrongly in the first occasion, it was wrongly called for the scan copy, my lord. Thereafter, on 30
Case that has come.
21. Siddhi kam, my lord, regarding service, my lord, we have talked, my lord, though verbally, my lord. It is, IO, my lord, tried to, my lord, serve the, my lord, but they refuse.
Okay, you submit that, will then proceed.
They refuse. It is but on
Verbal.
Verbal.
Can he have just a WhatsApp message to you?
Yes.
That will do. Just let him send a message to you that this is which is for this notice they have refused. We'll have a copy and record it and do it.
Because of the flag mark, why, my lord? Because I have also taken a step for
That's
registered AD, my lord.
that is received.
That is shown, my lord. Flag mark, why, my lord? On the next page, my lord, return with service, my lord, after service.
Okay, then we'll accept it service to you. CD is there.
My lord.
What is her statement? What is first tell us what is the age of the girl?
13 years.
13 years. And what is his age?
18, my lord.
Huh?
18, my lord.
Now what the girl says?
My lord, actually, the incident is not like that, my lord. Four boy, and 4 girl along with the victim. They went by a car from a different place, from Hagar to see the new bridge at Mahaputra.
Okay.
And during that, inside the car, they took alcohol. And another boy, Sontu, who is the owner of that car, see Taja. As per 164, 161, and all this. Medical, medical evidence also, above 14, below 16. Regarding sexual interviews, nothing, all.
So who is this? This is
He is one of the brother
Neighbor.
of her friend. Her his sister also in the car. Matlab,
My lord,
Then why he has been arrested?
my lord, for
No, he is not arrested.
arrested.
Oh, sorry. Oh, yes, he is
Yes.
arrested. Yes.
My lord.
But because of that, matlab, Pokso, brother of the girl, victim girl, rescued her inside the car in senseless condition. Because of
Hard,
investigation.
Swensus.
And she
It's an application
back.
arrested on
Arrested on my lord, 27/3.
27/3.
27/3/2024. Case there was called for, full stop, peruse the same.
Pokso.
After perusal of the case diary, this court has not found any sufficient incriminating material for further custodial interrogation of the petitioner, inasmuch as the stage of investigation do not warrant further custody of the petition. Accordingly, allowed the satisfaction of special judge
That's Pokso, my lord.
Pokso,
Kamrup Metro, Guwahati.
Kamrup Metro, 25,000.
Obliged, my lord.
For us, sir, উপরে দিন।
22.
Yes, Kotoki,
In this case, your lordship was, evident notice was served or not?
notice served.
That notice it's taken, I have contacted, but a report I have not received, my lord. But office note said no steps taken. That is probably regarding the
No, that-
register.
Register.
And even the merit of the case, my lord, perhaps, my lord, PW 1 and 2.
Hmm.
If your lordship go through, my lord, perhaps may not be a case of, my lord.
No, actually what happened, my lord?
Because
If your lordship goes to the evidence of PW 1 and 2,
1 and 2, my lord.
and
Very,
the
very
medical
specific,
evidence,
my lord.
Mm.
Very
would
specific.
have belied the prosecution case, my lord. Nothing has happened. A girl is at about 9 to 10 years. She was subject to sexual assault for 6 days continuously during a 1 month.
Statement,
Now,
my lord, inspires
so,
confidence.
and
confidence.
medical evidence shows that everything was intact, my
That is, will get a benefit in the
lord. No, your lordship, the whole case, your lordship, that cannot be, my lord. If that is the case, my lord, if she has been subject to sexual assault for 6 days, one after during the 1 month, my lord, and she was immediately, but in medical evidence says that there was no rupture, nothing was there, everything
No,
was.
there will be no rapture of a 7-year girl.
No, I understand, but no, nothing, my lord, has happened. Your lordship, had there been a meditation, my lord, there he should have sustained injuries, my lord. Nothing was, your lordship, I kindly see the medical evidence. The case where the
The
medical.
way she has described, there will be no injury.
No,
No, she has
There will
just
be no injury.
yeah.
She is
Yeah.
a 7-year-old boy,
not 9 to 10 years girl, my lord.
a girl, 9 to
10
10 years,
years, and
3
there
years
was
of girl.
say-
She says to be 7, and the way she has described,
That's why, my lord, she says about penetration, and that was done, my lord. And she shouted, my lord. Your lordship, she cried because of the penetration, my lord.
see, crying
There you are.
of a 9-year boy when a man of her father says, both of your child and her, she was playing together.
There you look.
She entered into your house.
Correct.
Then you get hold of her.
Yeah.
And it is not a case of penetration or something. It is just maybe touching.
No, but what she
That-
says, your
then
lordship,
it
can
is
see.
attractive.
Huh?
But she has-
there will be no injury. This is not a case.
No, your lordship, can see the statement of the girl. Statement of the girl is very clear, my lord.
Very clear. I have
yeah.
seen that.
That I know accused, I call him Dadu so and so. Accused took me inside or gave his mobile to so and so. That opened his wearing pants and he opened his shirt and pant and he started his pen inside my. Your lordship,
Forget about her use of word insert.
yeah, in that-
Can it
and-
be inserted
Your lordship, can
in that a situation? No.
no, you have to take it. What is the, we cannot,
No, that will be you cross-examine her. What is the insertion? She
No,
may
no.
explain.
Now she said that when I scream out of pain, then he scream, my lord. If there is a insertion, my lord,
We cannot go to all those at this bail stage.
your lord, at least your medical evidence, your lordship, see, I've enclosed the medical certificate, my lord. There is.
Suppose we believe her statement in that way, then also, even if there is no medical, there is a serious Yeah, the situation and
And she
suspicion.
has been said that this has been done continuously for another.
Nobody has
Yes,
examined now. till now.
Two examined, my lord.
Who?
Victim and her father, my lord.
Now let us see her statement in one deposition. I have seen the 164.
I'll enclose my lord, page 27, 26 is that,
And my lord, 6 days, my lord, she was assaulted, my lord.
continuously, my lord. If that is so, my lord, necessarily some injury should be left, my lord.
Uh, An incident came to light, my lord. That is also very, my lord, interesting, my lord. When our friend, my lord, that is the son of this accused, my lord. Somehow, my lord, he doubted, my lord, that something is there, my lord. Thereafter, he used to tease the victim, my lord. Then she reported her father. PW1 statement is very elaborate. I have not take it.
Have your lordship taken medical report, my lord?
No, no, will not say anything.
Medical report says, my lord, nothing was found. Everything was intact, my lord.
You get the benefit, have all benefit in the trial.
Mens rea
How
was not
many
attended.
witnesses are still to examine?
From the search.
Who examined?
To examine, how many total witnesses?
Total witnesses, I think, my lord,
Not many. my
The
lord.
prayer of Mr. Kotoki list this matter after summer break.
Eight witnesses.
After summer break.
totally false case, my lord.
Then we'll reject it.
No, my lord. If your lordship,
Hard petition dismissed.
if your lordship says, my lord, the manner in which he has used, my lord.
Dismissed. I have seen that. Yes, next case.
Okay, let it be after 4 weeks.
Okay, let it be after vacation.
We'll try one way.
After vacation. No, no, কিমান আছে মেটার? এটা এক কর। এটা অলপ পিছত, অলপমান পিছত। This civil bench will not get first preference.
After a week. After a week.
After a week. Yes.
Lordship, Parliamentary Council, Mr. A. Alam is legs in under court. The matter may be fixed for the time being.
What is this matter? Transfer. This is a transfer
Yes,
petition.
Lordship.
Yes, what is this case, Mr.?
My lord,
What is your case?
it's my lord.
What is the ground of seeking transfer?
Within husband and the wife. my
Okay,
lord.
what is the ground of seeking transfer?
The grounds, my lord, what happened, the cases are three cases are pending in the Tesco court.
Okay, let us see.
Yeah,
From transfer
yeah,
from
my
which place to which place?
My lord,
Transfer from Tezpur to
three cases, my lord. One
three
on the-
cases pending.
in the Court of Chief Judicial Magistrate, Tesco, my lord.
Hmm.
Under his establishment.
Okay,
that's-
in different courts, okay.
One is under 125 CRPC for seeking maintenance by the wife respondent. Another is by the section 5D domestic violence act, or section 12 domestic violence act, filed against the petitioner and her parents. Another for demand for dowry, etc. Allegedly demanded by the petitioner and her parent, my lord. The three cases are pending. The reason for transfer is that the father of the respondent wife and his uncle are serving in the establishment of the CGM test school.
So- Father of the,
Father and uncle of the respondent wife are serving in the test school, CGM court, my lord. Her brother is also a computer assistant in the same court, my lord, CGM court. And the wife of the computer assistant is just a judicial magistrate, my lord. She was working there, but by this time she has been transferred to Hailakandi, my lord. But the cases in court, domestic violence act is pending. In that court, the computer assistant is working, my lord. Because of that circumstances, the petitioner apprehends that the fear and impulsive.
what is the ground of apprehension? Mere apprehension will not do.
Appear that the surroundings, the circumstances,
What is the surrounding circumstances?
because of all these 3-4 employees are related to the wife, my lord. So the petitioner think that he may not be able to get the fair trial, my lord. So he wants to transfer from the Mongoldoy or Vishwanath Saili.
Where do he live? He is
Hello?
from which place?
Hello?
Petitioner is from which place?
Petitioner is also Tezpur. Wife is also Tezpur. Wife originally belonged to the Nagaon, my lord. It is Tezpur, my lord. So the distance between Tezpur and the Vishwanath Saili nowadays is only 45 kilometers. New highway. So it may be transferred to Vishwanath Saili court. They have not denied that transfer in their objection, but they have stated that, which is not provided in the law, that the AV cash is transferred, they are to be paid a cost of rupees 500, 2000 per day. But the cost is not provided under section 407 CRPC, my lord. The cost can be provided when the petition is that the vexatious, if it is dismissed, then cost can be imposed. Otherwise, for transfer, cost cannot be imposed. Section 407 CRPC. So my humble submission, my lord, as the chief for employees related to the petition respondents are working in that court, so there is a reasonable apprehension arose in the mind of the petitioner that he may not be able to get free and fair trial there. That is there. If your lordship think is reasonable, apprehension is reasonable and genuine, then it can be transferred. That is the spirit of law under section 407, my lord.
Heard Mr. Sharma, learned counsel for the petitioner. Also heard Mr.
M. Alam.
M. Alap, learned counsel for the respondent. The present application under section 407 of the Code of Criminal Procedure 1973 has been filed for transferring MR case number 125/2022, CR case number 825/2022, and PR case number 2163/2022. Full stop. MR case number 125/2022 has been filed by the respondent wife seeking respondent wife for what? First case. Let us first understand. That's why I'm dictating.
First case matter 125 seeking maintenance, and second one is PR case 2160/2022. It is a demand for dowry.
No,
And
just
another
go
one-
slow, go slow.
another one-
MR case number 125/2022 relates to what?
125
It relates to what?
That is my lord, the 125 case.
Seeking maintenance.
MR 120, yes, maintenance.
MR case number 125/2022 has been filed seeking maintenance by the respondent wife. Full stop. You have appeared now? No. Not yet?
I have appeared there.
Okay. Full stop. Then, MR CR case number 825/2022 has been lost by the respondent wife. Seeking what?
The demanded dowry by the petitioner.
Alleging
And our parent.
as alleging commission of offense under section 498A. Huh? 498A.
498, 406.
498A/406. Full stop. PR's case number
Yeah,
2163/2023 arises out of an FIR.
PR number 2160/2022, it is under section 498 and 406. And
I got
the
to 406, huh? No,
128
two cases, 492 cases or what?
it is
Because you
under
have not
it is
given
under
the details of the cases, why these are pending?
MR case number 125/22, CR case number
আপনি লিখো, হ্যাঁ, একবার লিখে দাও।
825. It is under Domestic Violence Act. Under is my lord.
But which was, Mrs. Sharma, just tell us MR case number 125/2022 is filed by the respondent wife under what provision?
125 CRPC.
125 CRPC seeking maintenance. Full stop. Then CR case number 825/2022 has been filed by the respondent number wife alleging
That is 125 to under section 12 is domestic violence secretary.
under section alleging file under not alleging file under section 12 of the
Domestic violence. Act.
Domestic Violence so and so Act. Okay. Now, PR case number 2163/2022 arises out of
For demand. Arising
FIR arising out of
Demand for
which police station?
Which police station? 406 490
Which police station? Police station of Rice.
There must be, when it's a PRC case, there must be an FIR investigation, charge sheet has been submitted.
It is filed in the court.
Understand, arising out of what?
That is a 825 under section 406 490.
Pending trial under section 498,
406 420.
406, 420.
PR case matter.
Full stop. The basic ground of challenge, the basic ground seeking transfer as urged by Mr. Sharma, a learned counsel, as well as pleaded in the present petition are to the effect that the father of the respondent number wife was working or is working?
Is working.
Was working or is working?
Is working.
Father is or was?
Father is also employee.
Is or was?
Is process server, my lord.
Is or was?
Retired or working? Asking whether he is retired or working.
No, they are working.
But you have written that was working.
Process server, my lord. The father is process server, uncle is process server, brother is computer
Is
assistant.
are. Okay.
Father is computer, brother wife
the
is judicial mate.
Father of the respondent wife is working as a Jari Karak in the establishment of Chief Judicial Magistrate Sonitpur, comma, the uncle of the petitioner, respondent is working as a Jari Karak in the same establishment, and the brother of the respondent wife is a computer assistant in the Court of Judicial Magistrate First Class Tezpur.
And he is working in the magistrate who is trying the PR case. 2160.
According to the petitioner, the sister-in-law of the respondent is a judicial magistrate first class, now posted at Karimganj. Full stop. Full stop. And therefore, in the aforesaid facts and circumstances, the petitioner apprehends that if the cases are tried and disposed of at Tezpur court, comma, they may not be able to get fair and impartial trial for the reason that there is every chance of being of the magistrates being influenced by the aforesaid employees and the sister-in-law who is a sister-in-law of the respondent wife. Accordingly, full stop. It is further it is the further contention that the apprehension expressed by the petitioner in genuine and reasonable reasonable. Therefore, this court may exercise its power under section 407 CRPC to transfer the aforesaid courts to any competent court near by any district nearby. Full stop. On the other hand, the learned counsel for the respondent wife has opposed such prayer and argues that contends that though a mere statement has been made that there is apprehension, reasonable apprehension, however, nothing material has been brought on record to have a satisfaction that the such apprehension of not getting free, fair and impartial justice is genuine and reasonable, and accordingly seeks that the petition should be dismissed. Full stop. The Honorable Apex Court in Ketena of decisions laid down the basic principle of exercise of power under section 407 CRPC when it is alleges apprehension of bias. Full stop. Apprehension of bias. Full stop. Full stop. Some of such important decisions are Gursaran Das Sadda versus State of Rajasthan. AIR within report AIR 1966 SC 1418, comma Maneka Sanjay Ganji versus Rani Jethmalani 1979 4 SCC 167. Abdul Najar Madani versus State of Tamil Nadu 2000 volume 6 SCC 204. Captain Amrinder Singh versus Prakash Singh Badal 2009 6 SCC 260. Nahar Singh Yadav versus Union of India and others. We have to find out the citation. First up, from the aforesaid judgments, the following ratios can be carved out. The following ratios and principles for exercise of power under section 407 CRPC can be called out. 1, 2, 3, 4, 5. 1. A case can be transferred in exercise of power under section 407 CRPC, comma, if there is a reasonable apprehension on the part of a party to a case that justice will not be done. He is entitled for such a transfer, comma, if he shows circumstances from which it can be inferred that he entertains an apprehension that it is reasonable in circumstances alleged. Full stop. Second, the apprehension must not only be entertained, but must appear to the court to be a reasonable apprehension. Third, assurance of a fair trial is the first imperative of the dispensation of justice and the central criteria for the court to consider when a motion of transfer is made is not the hypersensitivity or relative convenience of a party or easy availability of legal services or like services. Full stop. Something more substantial, comma, more compelling, comma, more imperiling, comma, from the point of view of public justice and its attendant environment is necessary if the court is to exercise its power of transfer. Next. For transfer of a criminal case, comma, there must be a reasonable apprehension on transfer of a case, apprehension of on the part of the party to a case that justice will not be done. It is one of the principles of administration of justice that justice should not only be done, but it should be seen to be done. On the other hand, mere allegation that there is apprehension of that justice will not be done in a given case does not suffice. In other words, comma, the court has further to see whether apprehension alleged is reasonable or not. The apprehension must not only be entertained, but must appear to the court to be a reasonable apprehension. Full stop. Now is the case in hand. On the now let this court examine the present case in the backdrop of aforesaid settled principle of law. From the discussion made herein above, it is clear that there is no rigid or inflexible rule or test that could be laid down to decide whether the power under section 407 of the CRPC should be exercised. However, what this court can conclude is that an order of transfer or trial is not to be passed as a matter of routine or merely because an interested party has expressed some apprehension about the proper conduct of a trial. Such power is to be exercised cautiously and in exceptional situations, comma, where it becomes necessary to do so to provide credibility to the trial. Full stop. In the case in hand, though it is not disputed that some of the relatives, as discussed herein above, some of the close relatives / family members of the respondent number wife are working in the established, working as under different capacities in the establishment of the Chief Judicial Magistrate Sonitpur, Tezpur. However, there is no material to suggest that the learned judges will be influenced or has been influenced by the employees, which are Jarikaraks, computer assistant, etc. Full stop. Here is no material to show that these officers who are trying the case of the petitioner is biased towards the petitioner, in as much as if transfers are allowed on such an apprehension, it will be an scar upon the independence of the judicial officers. Full stop. The court must be more cautious when apprehension of bias is expressed against the officers. Full stop. In the case in hand, there is no material to show except a statement of reasonable apprehension that the respondent wife or her relatives is in a position to influence the magistrate / trial judges. Full stop.
Computer assistant, he is attached to the magistrate, my lord.
Huh?
Computer assistant, he is attached to the magistrate who is trying the PR case, my lord.
Oh, that is fine, Mr. Sharma. You know, and he's an officer, judicial officer. If we
Anyhow,
record that a computer assistant can influence his,
That last
can
part,
this man influence me?
No, but that situation
That
has.
will give a wrong message to an officer. Why should we?
Implies apprehension in the mind of the petitioner. my
No,
lord.
mind may be lie. That can. Full stop. The pleadings made in this petition leaves no hesitation in the mind of this court that the allegations leveled by the application are vague and general in nature, inasmuch as such statements are not supported by any material on record to suggest that this computer assistant / Jarikaraks has been or are in a position to influence a judicial officer exercising his judicial duty. This court cannot be unmindful of the fact that allowing a transfer petition on the basis of such vague statement without any strong material will indirectly put a stigma upon the concerned magistrate / presiding officer, which may in turn demoralize such officer. Considering the above, this court finds no merit in this present application. Accordingly, same stands dismissed. The interim order passed earlier stands vacated. A copy of the order be sent to the concerned court.
My lord, just not on the record, material on record.
Though if not record, don't say anything.
Such cases, lordship is telling that as person on the judiciary, can such officers, if such allegation is there, can registry represent the officers? Because in some cases, whatever is stated.
Not necessary. We are here. Will in a case will not spare, and if we, in a case where necessary, will do them. We have even asked for a departmental proceeding in an officer in the last 2 days before.
Right.
Yes. Yes.
An application under section 397/397/401, madam. Jimma petition.
Passing.
Jimma petition, madam.
Jimma of what?
One vehicle and cash amount 7,000 and.
Yes, but Thakur, what is this?
Was called for whether any confiscation proceeding initiated against the vehicle or not, madam.
Hey, how like give dispose of. Let him give or what?
Matlab only the vehicle.
This is a vehicle, isn't it?
After trial, my lord.
Huh?
Vehicle and out to us.
Mobile.
One
One mobile.
What about mobile?
Mobile handset, mobile handset because this is an NDPS case. Maybe the police
Please, my lord.
will have to transfer all those data.
Data transferred, anything, what are
7,000. It was also
7,000 and what do you want? 7,000 also you want?
My lord, 7,700 actual, my lord.
Let,
Caesar list.
that also you want?
My lord.
Who are you? Driver?
Driver.
He is an accused, my lord.
Accused owner, he's been granted bail or what?
Together going to Guwahati to
From
No, tell us what is your story.
Bol-
I thought that only vehicle.
My lord, Caesar list, my lord.
Where is the seizure list?
Uh,
No, where is the
page
FIR?
16
Tell us.
16, my lord.
Huh?
Caesar list, my lord, 16 page, my lord.
Page 16, not
Connect-
FIR,
connect-
FIR.
Page 13. my lord.
FIR page 13.
Country. He is Afzalur Rahman.
Now you have been granted bail.
Yes, my lord. Accused already bail, my lord. Charge sheet already submit.
Where is the bail order?
No execute, my lord.
Where is the search sheet?
Charge sheet, my lord, page 21, my lord.
Where is that you are on bail? Anything that point of time you are outside?
Bail. No,
Where
my
is
lord.
that?
Defaulter bail, my lord.
Uh-huh.
Bail, already bail.
Default
granted.
bail.
Yes.
So there must be some mention in the search sheet
Yes.
that you are on bail. Where is that?
Charge sheet, my lord. Submit, my lord.
Search sheet submitted. I am asking, so from the search sheet that you are on bail on the date of filing search sheet. Oof. Come prepared on Monday, Tuesday. Please this matter on Tuesday. No, we cannot give it.
And we kept it a part of
Okay,
the
okay. Pursuant to this court's earlier order dated
on 29/5/24.
29/5/20, no, not before that.
My lord, 16, my lord. 16.
16/5/2024.
16/5/2024.
For this,
25
the officer in charge of Hajo PS case number 490/2023 has submitted that no confiscation proceeding in respect of the seized material has been initiated. Aforesaid communication addressed to the public prosecutor by the officer in charge dated 30th of May 2024 is kept on record. You prepare a list when the FIR was filed, when you have been granted bail, and where do you get it, and what are the materials. Okay, search sheet is filed, then we'll grant you. Do some hard work, you also. Judge will not do everything. Yes. Tuesday.
Monday, my lord.
Tuesday.
My lord, kindly
Monday, too many matters.
Tuesday. my
Come prepared, but
lord.
yes, Sitri, what is this?
May I please, your lordship, the other day, your lordship has called for my one affidavit.
What affidavit?
That affidavit in opposition was filed by me, my lord.
Is it there?
Your lordship has called for the records, my lord. If the affidavit in opposition does not come and then is not in record.
Affidavit is there?
Ase.
No, I have to know. When have you filed it?
My lord, I filed it on 8/8/22.
Huh?
Even
24/5/24.
21, I think.
The office note dated 29/5/2024 reflects that no affidavit on behalf of respondent number 3 has been filed. Though the respondent has made a submission that it has been filed.
My lord.
Because it is specifically say no affidavit on behalf of respondent 3 as stated by on the order dated so has been received by this section.
We have filed it, my lord.
Verified. The petitioner counsel is permitted to apprise the concerned section, concerned section in this regard.
My lord.
List this matter,
After,
list this matter on
Next week.
not next week, my lord.
not next week is too many matters
Yes, my
thereafter.
lord. Please, madam.
27th.
The lordship, but on 28, if the matter does not reaches, on 28, the matter is before the trial court.
Okay, the 22nd or something like that, give it. 21st.
21st of June.
June. Okay.
21st of June.
Much-
9 diarrhea, 9 yes. With all respect. क्या होगा
Hey, Smita, Smita now. Hey, last case to the Jimma ji to delay to what I told you. It is Jimma. Hey, last year, put up Mongol, but a Puri evolve. Yes, Mr. Nath.
Malad,
I was just waiting for your reply.
Lordship, I'm sorry, my lord, I
No, not an
could
issue. You are busy in every court. That's
could
not.
not make it.
But
yes,
what happened? Why we have fixed it is that otherwise everything will go out of mind.
Correct,
That's why.
correct. True,
Then
true,
we'll have a
true,
phrase and we'll make it CAB because these are important issues.
True.
We cannot dictate like in the court.
True, my lord.
So we'll after hearing you, we'll make it CAB and possibly next week we'll dictate this.
Lordship. My lord, since my lord factually.
Will it be possible on your part to complete by 12?
Yes.
1?
Yes. I'll take, my lord, I'll place 2 decisions of the honorable court. And 10-15.
Issue is here
Lord.
position is very clear that mandate say it is required. Now cognizance has been taken. It was not taken at that point of time, but subsequently it was granted. Now what will be the effect whether it is a grant of sanction post cognizance will vitiate the entire proceeding. That's all.
That is the issue.
That is the issue.
That is the issue.
If not, if yes,
Well,
yes,
if-
suppose, if not, that is fine. It will proceed. Case will be dismissed. Suppose we say that
Now it has come.
now it has come. Suppose I am
Lordship,
saying
lordship.
your case will be since already sanction is there. This will be a purely technical issue that it
Technical.
has been granted prior or post. Isn't that it?
Lordship.
Suppose we upheld your contention, there is no problem. We'll straight away dismiss this petition.
My lord.
But suppose we say that your content negate your contention, then there will be a critical issue. What should be done?
Right.
Mr. Bothakur says, in that event, we'll have to remand the matter for the court from the stage of cognizance. Okay, that is his contention, isn't it?
Press cognition, sir.
That is his contention.
The,
Now, what is the meaning of sending it to it? This is another. What is your contention? Suppose if it is your contention is upheld, allowed, fine. Nothing remains, we will dismiss this petition. Suppose we allow the Bothakur's contention that no sanction was necessary post his twofold argument. First is that sanction is very much necessary,
It is
even if it is assumed that you have your post cognizance sanction can be given. He is not agreeing, but he says can be given. Then also this is not in a sanction in the eye of law in terms of the rules, rule 3 and 4, because rule 3 and 4 prescribes a specific time period. So according to him, sanction should be a valid done by regular process. So this is his twofold argument,
Yes.
isn't it, Bothakur?
yes,
So suppose we upheld, then what next?
but if lordship, my lord, accepts the petition
Hmm.
and held that the
Sanctions, the cognizance is bad.
Cognizance is bad.
Uh,
Then it will go
See,
back, it
if
will go
we
back to
say,
the
if
court
we
only, my lord,
say
because
that
now
this
both
is
the states are
bad,
there.
then what we can say is cognizance is bad. We cannot
Bad.
say that investigation is bad.
No,
We
or the
cannot
sanction,
say.
or the sanction is bad. Sanction is not under challenge.
No.
I will place, matlab, the records are with me. I will place that sanction has been properly given, but it is besides the issue here that it is not under challenge. Even then I will place. Matlab, what in that case?
No,
matlab,
that will hear you. Before that, just I want to,
No.
if we accept his argument, what next?
Then matlab, it will go back to the court. It will go back to the court. Court will start
Then
from that.
it
phase.
is only a technical order,
It is-
no relief to the,
Yes, yes.
Your Lordship,
Absolutely.
ultimately, your Lordship,
Absolutely.
your Lordship will have to discharge first meeting. Because your Lordship, search framing is also will have.
okay, of course, set aside that order.
That order.
The moment set aside this order,
If
you
cognizance
cannot be
was-
released on bail.
Because your Lordship, ultimately, if that order goes, I will have to be discharged, your Lordship. And it will have to.
No, you are not discharged. Your charge sheet remains.
The charge sheet remains.
So charge sheet remains, and in terms of new judgment, for want of sanction, default bail cannot be granted.
No, no. That's
Question of
okay.
bail is not there, your Lordship.
No question of bail is not
Bail
there.
is
So
not
you will be inside.
That your Lordship will decide.
No,
matlab,
that is
matlab,
what I am
that
asking.
My
that is
humble submission will be on that point, your Lordship. Ultimately, since we have challenged the order, your Lordship, framing charge, your Lordship,
Mm.
the moment your Lordship set aside that order, your
Mm.
Lordship, then they will have to be discharged. And then your Lordship, from the stage of cognizance, they will have to issue notice.
Understanding. But the fact remains that there was an FIR,
Lordship,
there was an investigation,
Lordship,
and after investigation, they have filed a charge sheet against you.
Lordship,
And on the date of filing of the charge sheet, you were inside.
Lordship.
You are inside. So if you are inside, now what the discharge will mean? Discharge will not mean you are acquitted.
no, only
Lordship, the
charge,
moment
filling of
we-
charge.
It will not be a discharge per se. It will be a setting aside of the order, a framing charge, asking a de novo process.
Yes.
Not only your Lordship, because your Lordship, it will not only be your Lordship charge, your Lordship will have to, it will have to go back to the stage of issuing or taking cognizance.
Cognizance.
Cognizance by the
Now-
session judge, Lord.
No, cognizance by the session judge here.
Session judge. Session
Sir,
judge.
We understand. You say that there is a first stage of taking cognizance.
cognizance.
Second stage is of framing charges. So if the cognizance if the cognizance is bad, all subsequent things
Action bad,
action is bad.
bad,
So this order of discharge will also go.
go.
Will that mean that you are discharged from the entire prosecution?
Lordship, we will have to, my humble submission. your
That
Lordship.
is
Lordship, my humble
critical
submission
issue.
will be, my humble submission will be, the petitioners will have to be, your Lordship, discharged. And then, your Lordship, from the stage of cognizance, your Lordship, notice will have to be issued. And on that particular day, they will have to, when they will appear, they will have to apply for bail. And if your Lordship, court feels that
No,
they
that is a different issue. But
if
it
court
can,
feel,
we cannot suppose it in the event we take your propositions to be correct, then also there cannot be any direction of you releasing on bail.
no, bail, question of bail is not there. Once your Lordship discharged, then your Lordship, question of bail is not there. Discharge means, your Lordship, he is discharged. Now your Lordship, accused is discharged. He will have to be released, your Lordship, when he is discharged, your Lordship. Now, your Lordship, on this, from the stage of cognizance, your Lordship, they will have to start the process. Note, someone will be issued, they will have to appear. And on their appearance, your Lordship, court may put them behind bar, your Lordship. Since these are all non-bailable sections, bail is not there. That's my humble submission.
Okay, let us hear,
Let-
Mr. That is a ancillary question. Now
Lord.
let us have satisfaction from Mr. Nath's.
Malad, just to responding to that, Malad, my respectful submission would be, Malad, if the order dated 13/9/23 is not in picture, suppose this order cannot sustain, this is not in picture. What would be the situation? Situation is charge sheet is already filed before the court. It is there, and the court is waiting for the sanction order. Now on 13/10/2023.
Because discharge will not be on merit. Your argument will be discharge be not on merit because of a ground that it is a nullity by virtue of the want of sanction. So if want of sanction, it will start from the stage Cognizance.
Well, that is what, my lord,
Ah.
two things.
Mm.
Suppose the accepting the contention of the petitioner, charge sheet is there, sanction will
Now,
come.
now answer me a question.
Lordship,
Okay, okay, you proceed your case. I have 2, 3 questions to ask.
lordship,
You just proceed your argument.
my lord,
Then I will come back to both of you.
my lord.
Yes.
My lord, the thing
If
is,
necessary, if the bench rises, we'll try to have or on Monday.
lordship, definitely, definitely. I'll try to put my submissions, my lord.
No, you
to
can
this.
complete, but there may be
Lord,
hundreds of questions inside
I'll-
my mind.
I'll definitely.
So then I will come back on Monday. Okay? Monday or Tuesday as per your convenience.
Absolutely.
Yes.
My lord,
In the meantime, we'll dictate the facts and your arguments.
yes,
And then on Monday, we'll dictate the final order in the court.
my lord. My lord, here the specific challenge in this case is just I'm indicating because that is very important. Paragraph 10. Paragraph 10 of the petition, my lord,
Just a minute.
both the petitions are, my lord, similar. I am holding, my lord, if lordship kindly holds up.
He argued from this petition. But Thakur, you argued from?
1108. Yes,
1108.
I'm also arguing that only
1108.
1108/23. Zakir Hussain, my lord.
Just a minute. Yes.
If lordship kindly comes to para 10, that is the entire thrust of the case. That
Paragraph 10, page
para 10, page 9.
9.
The petitioner begs to submit that this
Just a minute. Paragraph 10. Of the petition,
of the petition, my lord.
page 9.
Page 9, para 10. This is the entire case, my lord. The petitioner begs to submit that the section 45 of the UP Act starts with non-optional clause, and this clearly makes it mandatory for the trial court not to take cognizance of the offense without previous sanction of the competent government. And the section under which cognizance was taken and charge was framed under chapter 3 and 4 of the UP Act 1967, and therefore previous sanction from the competent government authority is mandatory in nature. There is no more res integra that the issue of sanction goes to the root of the matter, and absence thereof vitiates the order. Order, that is the impugn order, my lord, of 13(9). If the order of taking cognizance, which is the foundation of the trial proceeding, is bad, in that event, the superstructure built thereupon will also be vitiated. In the instant case, the order taking cognizance is bad, the learned court below could not have gone further to frame charge. It is humbly submitted that the petitioner, by the petitioner, that the impugn order on the face of it bathed in law, as well as liable to be set aside. So this is the basic case. Otherwise, in the subsequent paragraphs, he said that I am not involved in.
So these are, we are not concerned.
Logic. On the
Whether they are terrorists or not, subject, merit, we are not.
So logic will not concern. So, my lord, the dates are important, my lord. The kindly just from the petition itself only.
I'll take note, just tell me.
I'm indicating the date, my lord. On 7/4/23, the FIR was lost.
7/4/2023.
Lordship.
FIR.
FIR. On 16/4/2023, forwarding report. My lord, yes. Annexure 2, my lord, page 18. And 6/7/2023, my lord, charge sheet was submitted.
6/7/2023.
Charge sheet submitted, my lord. Under section 13.
And 18. 13 and 18, that we have recorded yesterday.
Lordship.
Okay.
Then, my lord, the impugn order was passed on. In between, there are some dates, my lord. I'll just indicate from the petition. They have stated that on 13/9/2023, although this has been wrongly typed, my lord, as 13/8.
13/9.
In the writ petition, it is typed as 13/8, but it is 13/9. Lord, 13/9, the order on the learned session judge has passed the order and framed the charge, Lord. Under section 10, 13/8.
13/9/2023, this is the impugn order.
This is the impugn order. In between, my lord, what has happened? I don't know, my lord, how 13/9 order petition was filed on 4th of September. I just have some difficulty in understanding that, my lord. The affidavit is on 4th of September. My copy at least.
Anyway, what happened that
Look.
he is referring to a paragraph that on the date of search sheet, that is on 6/7/23. The IO has said that sanction is sought for,
Yes.
sanction is pending.
Yes. On 7/7/2023, SP Borpeta wrote to the Commissioner and Secretary through
That is
ICP.
from your record?
Yes, from my record.
Okay, okay, just this is important.
Yes.
Just I'll record it.
Yes, yes. I have the branch for that. I'll place it.
On 7/7/2023,
On 7/7/2023,
2023,
SP Borpeta wrote to the Commissioner and Secretary Home through IGP Western Range
seeking sanction.
seeking sanction. Then my lord, it went to IGP. So IGP sent it on 31/7/2023. 31/7.
31/7/2023
23.
to IGP to
IGP to Commissioner and Secretary. As
Home.
Home.
Commissioner and Secretary Home.
Lodge. Lodge.
Just you flag mark it, all these things.
Yes, my lord.
Then
Then the matter was placed as per Rule 8, my lord,
Hmm.
2008 rule.
Hmm.
It was placed before the Independent Review Committee on 11/10/2023.
11/10/2023
23.
Independent Review Committee.
Review committee was placed before the committee, my lord. Then the review committee immediately on that day passed an order that it will be considered on next day, accordingly intimated to us. There is an order, lordship will find that I'm indicating the serial number of the page. 87 is the page 87 in the record is the 11/10/2023. It was placed before the Independent Review Committee. Then lordship will find page 90 is the order of the
Just a
independent.
flag mark it, hi, this.
Yes,
but
yes, my lord.
Page
Independent
90
review.
is the,
Page 90, Independent Review Committee's order of 11/10/2023. They said that we will consider it on next day.
okay.
Then, my lord, page 89, my lord, arrangement of pages are little bit.
Maybe you just flag mark it.
Yes, yes. Page 89,
Important documents you flag mark it.
yes.
Hmm.
12, 12/10/2023.
Hmm.
This is the order by the committee, my lord. Ordered the committee,
Ordered by the government
committee.
committee.
For
It was on 11/10, they said we'll pass later on. On
next,
12/10,
they passed.
they passed it.
The report at page 91. The detailed report of the Independent Review Committee, lordship will find at page 91,
Hmm.
12/10/2023 report. Then on 13/10/2023,
The order was passed.
order was passed. So these are the days, my lord.
It was highest pending in the office of the IGP commission. Commissioner's office.
Commissioner's office.
Because see, even if we assume that it's 6, okay. 6 charge sheet was filed, 7 it was sent. So it should be 6 from 7 days, na? 6. So as SP has rightly sent in time, we may say time. Then IGP received on which date?
IGP SP has sent on 7/7
He will receive on the same date.
on same date possible, on same date. 87, 89, 90. Not available. But if lordship kindly takes up the 2008 rules
Okay.
for recommendation and sanction of prosecution
Hmm.
rules.
Where is that?
Well, in the
UAP,
barrack
UAP.
rule is there.
Yes, yes. I will keep this book here if necessary for anything. Rule, which rule?
2008 rules,
Review committee rules.
so review rules, yeah, unlawful activities prevention, recommendation and sanction of prosecution rules 2008.
Okay.
38, madam, page 38, maybe,
Just 7 minutes, page 38, na?
maybe. Madam.
Okay, flagged it. Already flagged mark. Rule, which rule you want to show?
3, my lord.
3.
Time limit for making a recommendation by the authority.
Mm.
The authority shall, under subsection 2 of section 45 of the Act, make its report containing the recommendations of the central government, or as the case may be, the state government, within 7 working days of receipt of the evidence gathered by the investigating officer under the code. Then next is 4 is time limit for sanction of prosecution. The central government, or as the case may be, the state government shall, under subsection 2 of section 45 of the Act, takes a decision regarding sanction for prosecution within 7 working days after receipt of recommendation of the authority. So, Lord, the
So
authority.
your whole argument is
Mal-
that this 7 day is mandated for the recommending authority,
recommending authority.
not for others.
No.
So therefore, they received within time, they have done within time, and subsequently the sanctioning authority has also done within the time.
Within time.
So therefore, no violation of rule 3 and 4.
3 and 4.
This is your case.
Yes. Lord. 7 days time.
According to you, this is not mandated for the investigating officer to send the report within no time limit is prescribed for the investigating officer to send.
Yes.
This is your-
Logic.
I couldn't.
And my lord, if the sanction is delayed, that is also, I'll place, my lord, what will happen. Ultimately, that clinches the issue, my lord. So this is my submission as regard the time limit, my lord. My lord, I have, my lord, with all respect, my lord, I have got 2 decisions.
Hmm.
One says that the sanction, lordship will see whether the non-giving of sanction will go to the root of the matter or not. If it goes to the root, it is mandatory and the proceeding will be vitiated. If it doesn't go to root of the matter, then it is not vitiated, my lord.
Since all judgments Mr. Bhattacharya is relied on, admittedly, it relates to the pre-UAPA era, and this is under the SADA Act.
Logic.
And there is no judgment. I have also searched on the point of this section 45. There are some judgments so far relating to the relation between sanction and the default bail. That is there.
Default bill, lordship, is not a matter of right.
No.
Because of pendency of sanction, they
That
will
will
get
not
the
be.
bill.
That will not be.
That-
That has
that-
been
they will-
clarified in recent judgment.
Yes, they will.
brought that.
Yes.
My lord, this is, lordship, I just did not take the book. If book is maybe there, my lord. 2011 4 SSC 402.
Just give us
2011
2011
4 SCC 402.
402.
Photo का नाम copy लिखो। हाँ, okay. लो। नहीं तो नहीं कर photo पे जाएंगे। मतलब here, lordship में
Just a minute.
lordship. File लो। कौन आएगा? तो मारेंगे मोड़ा पता चला ना?
Oh, you have the book. Okay.
Lordship. 11 4 SCC
402.
402.
Yeah, that is mail to.
Ashok Testring Bhutia.
Page
Page 402, my lord.
PC Act.
PCA.
Page
PCA,
402.
PCA.
Just give me a minute.
Lordship.
Where is the petitioner for this case? But I would go through it. If statutory period is over, we'll dispose it of. Huh? Just you have the instruction. We may not come at 2. Yes. We may sit for 5-10 minutes more, but will not come back.
19
Yes.
onwards.
Paragraph which whatever?
Malad, the Lordship paragraph kindly come to 16.
1-6.
7 onwards, Malad.
Paragraph 16.
17 onwards, Malad. 17. Lordship.
Yes.
But better Lordship come to para 19. 19. Malad. Para 19. It has further been submitted.
Para 19, na? Just a
One
minute.
minute.
Yes.
It has further been submitted that an invalid sanction cannot be the foundation for the prosecution, and thus the entire investigation and trial should vitiate, and the investigation without proper authorization and invalid sanction goes to the root of the jurisdiction of the court, and so the conviction cannot stand. Their conviction was there, prosecution sanction was not there. Malad, two issues are they are decided by the court. I'm just, Lordship may allow me to read paragraph 20 onwards, Malad.
Yes.
Till 26, Malad.
Okay, no issue.
Lordship. The issues raised herein above are no more res integra. The matter of investigation of an officer not authorized by law has been considered by this court time and again, and it has consistently been held that a defect or irregularity in investigation, however serious, has no direct bearing on the competence or procedure relating to the cognizance or the trial, and therefore, where the cognizance of the case has in fact been taken and the case has proceeded to termination, the invalidity of the precedent investigation does not vitiate the result unless a miscarriage of justice has been caused thereby. The defect or irregularity in investigation has no bearing on the competence of the court or procedure relating to cognizance or trial. Then some case laws are discussed. Kindly, in Kalpat, next para, in Kalpat Rai versus so and so, a case under the previous provisions of section 20 of the terrorist TADA, this court considered the issue as to whether an oral direction to an officer to conduct investigation could meet the requirement of law. After considering the statutory provisions, the court come to the conclusion that an oral approval was obtained from the competent officer concerned. It was sufficient to legalize the further action. In state of so-and-so versus Surya Khan so-and-so, 2 judge bench of this court had taken a contrary view without taking note of the earlier two judge bench judgment so-and-so and held as under. When a statutory functionary passes an order that to authorizing a person to carry out public function like investigation into an offense, an order of writing was required to be passed, and statutory functionary must act in a manner laid down in the statute. Issuance of an oral direction is not contemplated under the Act. Such a concept is known in administrative law. The statutory functionaries are enjoined with a duty to pass written orders. Next para 23. In the instant case, the officer had mentioned in the FIR itself that he had orally been directed by the SP to investigate the case. It is evident from the above that the judgment in Kalpat Rai and Surya Sankaran Kari have been decided by 2 judge bench of this court, and in the later judgment, the earlier judgment of the court in Kalpat Rai has not been taken note of. Technically speaking, it can be held to be par incuriam. There is nothing on record to show that the officer's statement is not factually correct. We have no occasion to decide as to which of the earlier judgment is binding. Then Lordship may skip that and kindly come to the next para. The same remain the position regarding sanction. I'm stressing on this. But there
Paragraph 23.
Paragraph 25.
25.
After 20, Lordship 25. The same remain the position regarding sanction. Well, in the previous paragraph, Lordship has seen that is as regard initiation of investigation. The allegation was that there is no written order. It was a verbal order only. And the prosecution, the defense could not prove so that in fact there was no order. Even on the strength of the verbal order of the SP, investigation was started and that was accepted. Then the Honorable Court has said in paragraph 25 that doesn't go to the root of the merit because the the same remain the position
No,
as regards sanction.
yes, you are correct. But you'll have to see the statutory prescription under PC Act. PC Act, there are two stages of sanction. One is under 17A, which says if you cannot even start an inquiry, investigation or inquiry in certain offenses, or maybe in cases of PC Act relatable to any decision. This is a pre-investigation sanction. And other section which says it's a pre-cognizance, post-investigation pre-cognizance section. However, the statute prescribes itself that this specific what you have said, that there shall not be appellate court or revisional court will not entertain or set aside a judgment only on the ground of this technical issue. This is a
Failure-
specific
Lordship
prescription.
will see whether by not doing that, failure of justice has been caused. That is the thrust. Para 25, the next line, my lord.
Hmm.
In absence of anything to show,
PC Act.
in absence of anything to show
Hmm.
that any defect or irregularity therein caused a failure of justice, the
Without
plea is without substance. A failure of justice is relatable to error, omission, or irregularity in sanction. Therefore, a mere error, omission, or irregularity in sanction is not considered to be fatal unless it has resulted in a failure
Sure.
of justice or has been occasioned thereby. So that is my respectful submission that Lordship will see whether any
Okay,
failure
okay,
of
I
justice has
understand.
been
Your
caused.
argument is
Lord.
that this assuming for a moment that there is no sanction,
No,
but
Lord.
sanction is subsequently granted,
Lordship.
and that sanction is regular in terms of Rule 3 and 4 within time, and therefore such irregularity, even sanction is given at a later point of time, sanction is given, that will not vitiate the entire proceeding.
Lord.
That will not go to the root of the matter, and this is an irregularity, curable irregularity, which has already been cured.
It is cured, and my lord, this doesn't cause any failure of justice, my lord.
Hmm.
Now, Lordship, I'll take your Lordship to the other decision, my lord. Lordship
Just
may-
a minute, huh? No failure of justice.
Now, my lord, why?
Just a minute.
My lord.
Okay, next.
In subsequent paragraphs, 465 and all these things,
That is
I'll not take your Lordship to that. Well, this is the decision in the case of Jajbir Singh alias Jabir Singh. Lordship, I have a copy of that. In this case, my lord, the why 45 has been brought. It is also mentioned, my lord. I'll take your Lordship to
Okay.
that also, my lord.
This is the case where, yes.
Ultimately,
No, understand, you may,
bail and sanction.
you want to rely on that relevance of sanction part in this,
True.
and what is the intent?
True.
Yes, let us see.
Well, this is the position of the Honorable Apex Court. We can't have separate decision. Well, this is the ultimately.
Yes, where is that?
Well, I'll take your Lordship to first kindly come to para 3. These are the issues.
Para 3.
These are the issues. And while deciding the issues, I'll
Paragraph 3, yes.
Lordship. These seminal issues falling for the consideration of this court may be formulated as under whether an accused is entitled to seek default bail under the provisions of section 167(2) of the Criminal Procedure Code 1973 on the ground that although the charge sheet might have been filed within the statutory time period as prescribed in law, yet the charge sheet sans a valid order of sanction passed by a competent authority is no longer a charge sheet in the eye of law, and therefore it is as good as saying that no charge sheet was filed by the investigating agency within the statutory time period as prescribed in law. To put it more sanctionally, whether the court concerned is precluded in any manner for the purpose of 167 of the CRPC from taking notice of the charge sheet that might have been filed by the investigating agency in the absence of a valid sanction order. But that if the 7 days period and all these things, as has been urged by the petitioner, is accepted, then these things will come. This will not come, that is my submission, my lord. And next thing, my lord, whether the cognizance of the charge sheet is necessary to prevent an accused. Cognizance of the charge sheet is necessary to prevent an accused from seeking default bail, or whether mere filing of charge sheet would suffice for the investigation to be deemed complete. To put it in a different words, whether the grant of sanction is contemplated under section 167 CRPC. Well, basically here we are concerned with these two issues. Then Lordship may kindly come.
I think three may be more important than two.
Lordship. A special court may not.
Because in three, the issues is framed which answers the question. So therefore we'll go to the three.
Yes, sir. Lordship.
This may be the question also, how it is dealt with, that may be some relevance.
Lordship. A special court may not be in a position to take cognizance on account of failure on the part of the prosecution to obtain sanction to prosecute.
So it
the
is
accused.
presumed that you cannot take cognizance. However, whether in bail it will have a relevance. So how does,
The
where is
question
the
of-
three?
question of bail is not here, my lord. That
No,
will-
not
that-
here.
My lord, so failure on the part of the prosecution to obtain sanction to prosecute the accused under UAPA and the 1908 Act, but does such failure amount to non-compliance of the provisions of section 167(2) of the CRPC so as to entitle the accused to seek default bail. It is on that default bail he will not get. Then kindly see, my lord, the argument of the petitioner, para 8.
Right?
Logic.
Just a
That is relevant for us, my lord.
right, yes. Yes, Bhattakur. Search sheet submitted. Being search sheet number, we will have to do simultaneous work. Search 33/24. That is 34. 34/24. Search sheet is already filed. Seek petitioner is granted liberty to approach the learned trial court seeking regular bail. In the event such application is filed, the same be considered as per law. We have disposed of another method.
Okay, lots of-
No way out, we'll have to do simultaneous.
Correct. Lots.
Yes.
Para 8, according to both the learned counsels, the charge sheet filed without sanction is an incomplete charge sheet, and on the basis of such incomplete charge sheet, no cognizance can be taken. It was submitted that the final report is filed so as to enable the court concerned to apply its mind as to whether cognizance of the offense should be taken or not. The sum and substance of the submission canvassed on behalf of the accused persons is that there cannot be a part charge sheet. A charge sheet filed without sanction is incomplete charge sheet and does not meet the requirement of a police report within the meaning of section 173(2) of the CRPC. Such a charge sheet would also not be in consonance with subsection 5 of section 173 of CRPC. This is the argument, my lord, I find concerning, my lord, our issue. Lordship. Then, my lord, Lordship may kindly come to respondent's argument, para 19.
Para?
19.
Yes.
Para 19, so Mr. So-and-so vehemently submitted that there is no merit in the submission canvassed on behalf of the accused persons that a charge sheet without requisite sanction under the UAPA or the 1908 Act is incomplete. In other words, according to Mr. So-and-so, there is no merit in the contention canvassed on behalf of the accused persons that although the charge sheet was filed within the period of 180 days, yet the same being without sanction, it could be said to be as good as not filing the charge sheet within the statutory period of time. So that is the contention of the respondent. There is no, we said that there is no merit. Then, my lord, the submission para 20 also, in the context, Mr. So-and-so invited the attention of this court on the following aspects. Number A, the act of grant of sanction for prosecution in several statutes is entrusted upon the authority other than the investigating agency, and as such, it is not within the domain of the investigating agency to grant such sanction. In the present case, at the time of filing of the first charge sheet of by the state investigating agency, the SIA had already sought sanction for prosecution from the appropriate governments. The cognizance of the offense was taken by the special court on 5/4/2023. Only after the sanction under so-and-so and so-and-so were granted by the appropriate government. And the question of grant of sanction for prosecution is relevant only at the stage of taking cognizance, which is altogether a separate stage distinct from the stage of investigation. Malad, there 2013 that case has been referred. Malad, next kindly, this is I find malad the which is altogether a separate stage distinct from the stage of investigation. Reliance is placed on so and so. Then malad, para 34, the provision of 45 has been quoted by the Honorable Court. Para 34, malad.
Just a minute.
Lordship.
Question number 3 is not answered.
No, in fact, in between discussions are there, and court has clarified that it is totally different. Bail is not default bail, they will.
No, that is not, that we have already.
That is why I said that is not the issue with us, because I am not on bail. Malad, then I'll take your lordship to para 34, malad.
Para 34.
34, malad, the section 45 has been of the UAP Act has been quoted, malad. Para 34(5). A close look at section 45 of the UAPA referred to above would indicate that subsection 1 deals with the authority who can accord sanction for the offense committed under UAPA, whereas subsection 2 deals with the procedure to be followed by the authority at the time of granting sanction. But 45(2), just for a moment, Lordship may take note, I'll read later. It is evident from section 45(1) of the UAPA that if the offense falls under so and so, the court shall not take cognizance of the offenses unless previous sanction is accorded either by the central government or by the officer authorized by the central government in this behalf. If the offense alleged to have been committed under so and so falls under chapter 4 and 6, the court shall not take cognizance of the offense unless the previous sanction is granted by the central government or so and so. Then, my lord, we must read section 45 of UAPA referred to above along with the rule 3 and 4, which I have already read, my lord. That those are the rule of 2008. Then para 37, the rules 2008 referred to above would indicate that the authority shall under subsection 2 of section 45 UAPA make its report containing the recommendations to the central government or as the case may be the state government within 7 working days of receipt of the evidence gathered by the investigating officer under CRPC. So the recommending authority, they got the entire material in our case on 11/10, and they accordingly within the statutory period they have done. The central government or as the case may be the state government is obliged under subsection 2 of this section 45 of the UAPA to take decision regarding sanction for prosecution within 7 working days after receipt of the recommendations of the authority. So that period is then. Why that provision has been taken at paragraph 38, it is said. In the aforesaid context, our attention was drawn by the learned counsel appearing for the appellants to the speech of the Honorable Home Minister while moving the draft bill in Rajya Sabha, and in his speech, the Honorable Minister clearly stated as under. Finally, sir, we have incorporated a very salutary provision. To the best of our knowledge, I don't know, I may be corrected by the law minister or the law secretary later. It is the first time we are introducing this in a prosecution under UAPA now. It is the executive government which register the case through a police officer. It is the executive government which investigates the case through an investigating agency, namely the police department. It is the executive government which sanctions under section 45. Therefore, there is a fear that a vindicative or wrong executive government could register a case, investigate and sanction prosecution. There is a fear. Maybe it is not a fear that is entirely justified, but you cannot say that it is entirely unjustified. So what we are doing, the executive government can register the case because no one else can register a case. The executive government, though, through its agency can investigate the case, but before sanction is granted under section 45(1), we are interposing an independent authority which will review the entire evidence gathered in the investigation and then makes a recommendation whether this is a fit case for prosecution. So here we are bringing a filter, a buffer, an independent authority who has to review the entire evidence that is gathered and then make a recommendation to the state government and the central government as the case may be a fit case for sanction. I think this is the very salutary safeguard. All sections of the house should welcome it. This is the biggest buffer against arbitrariness, which many members spoke about. Sir, these are the features of the bill. So, the intention of bringing, I mean, on that, Malad, intention of bringing that sanction under 45(2), this is the purpose that an independent body under the 2008 rules, they will examine the records, evidences, and they will give their report. The recommendation has been given here, Malad. It is before your lordship. Malad. The report within the 7 days period they received, they have done. And next within 7 days period after receipt of the recommendation, the prosecution sanction has been given. And Malad, the impugn order was passed on 13/9/2023. Recommendation came on 13/10/2023. In between, Malad,
Okay,
process was.
we'll do it today. Can you wait? I do not know about,
That
we do not know how
special
much
bench, Your
this that will run.
Bench is there.
Special
It will
bench
be
is
on Monday, Malad, will come.
Monday?
Up
Monday.
to you.
Just mind one,
Malad.
just you keep in mind. The Home Minister's statement as recorded at paragraph 38. It says an object. What is the object? That let there be an independent body to scrutinize and recommend that yes, we give a sanction. So there is a purpose. So purpose is to have a second opinion, not of the investigating authority. And Nivitri says this. A special protection, second stage of layer is given that there will be an independent authority. It will apply its own mind and give yes or no. This will have a meaning. Now, how can a magistrate, okay, we accept, suppose for a moment, that the prosecution ought to have said that you cannot proceed in this case because you are awaiting for a sanction. This is one. Other aspect is, just think over it. 2 stages, if we go by your argument under rule 3 and 4 and 5 or 3 and 4, that there are time frame given to the authorities. Receipt of the investigation material, because sanction cannot be granted on air or cannot be refused on air. So therefore, what material is what has been collected by the investigating officer that is to be placed before the statutory authority, reviewing authority. And Parliament, its wisdom, has given them only 7 days. And the authority to act upon it for 7 days, very strict. Now, there is no period for the investigating officer to
Send it to the
independent authority. However, it must be after completion of the investigation. It cannot be beyond, because whatever he has collected. So at least at that day, it should start on the date of investigation. And if the authority in the meantime keeps on keeping it pending for months, from June to October, from July to October, how you will cure this? Because the object is very important. Even the legislature has not given more than 7 days time. How will you read this action of these people? We are not saying that this will vitiate the entire thing, but there must be some guideline, any guideline on your part. Any guideline on your part, because this officer will sit over. That is having a resultant effect upon the person who is inside jail. There may be a refusal of sanction. Then, because there is not that it is always be granted. If there is a refusal of sanction, then who will compensate that person for this period? This question will have to answer Monday. Keep this in the keep these judgments and my note in the chamber for Saturday, Sunday, hot food for thought, and rest, send the files on Monday. Okay, so he'll not come back. List is over. Some other works will complete.
Lord, on Monday, Lordship,
No, as per
I-
your convenience.
I will pray that if not inconvenient to Lordship and my senior friends, at 2 week.
As per your convenience. No issue. You complete, let him also complete other jobs.
Lord,
You also complete.
Lord.
We'll do it.